pending. Posted for orders on bills.
It's in a pending matter. I filed an IA for stay in the pendency, my lords, against the order of this honorable court. They have issued a seniority list which goes against already disposed of matter, my lords, against which I had filed urgency, my lords, because they're going and appointing matters. Moved for today, it's not listed for tomorrow, my lords.
My lords.
29. Order list up to 20.
ಆಡಿಯೋ ಬರ್ತಾ ಇಲ್ಲ.
Adjournments, list 1, page number 1, 1 to 4, page number 2, serial number 5 to 11, page number 3, 12 to 17, page number 4, 18 to 24.
24 man.
Yes.
Sir. 25.
Srinivasvi. Page number 5, serial number 25 to 27.
25. Respondent advocate. I have to take instruction from the department.
PM Naik.
On 2 weeks time. I will have to file my statement and get instructions also.
10 days. I'll fix a date, no further adjournment.
Please.
The old matter.
Yes.
10 days date.
6th of November. 6th of November. Page number 6, serial number 28 to 29. Abhishek. Ibu.
You have informed the other side. You have informed. I request. Relist the matter on.
30th. Page number 7, 30 to 33. Page number 8, 34. Page number 9, 35 to 39. 39.
Who's the other side? Have you informed the other side?
Anupama.
I inform and report to the court officer. Otherwise, you wait when the matter reaches it. Yes.
Page number 10, 40 to 44.
You have informed.
Sharath S.
At request, relist the matter on.
6th of November.
Yes.
Page number 11, 45. Page number 12, 46 to 50. Page number 13, 51 to 56.
Plus 52. I have informed the petitioner counsel. I appear for respondent number 2, Moda, 2 weeks time, my lords, to file objections.
Who's the third respondent?
I appear for Moda, my lords, respondent number 2.
Who
Member
appears for the
Secretary
third respondent? Is there no standing counsel?
Yarige?
Ram Durga Planning Authority.
I'm not aware of standing counsel.
Nobody
Pass
filed
the
wakalat.
peti-
Madam.
Huh?
Nobody appears for Ram Durga Planning Authority. I'm appearing for petitioner, madam.
Correct, but somebody must appear. Is there say required in your matter?
Muda has passed the order, so probably Muda's say must be.
Third is not necessary.
I'm yet to see the
Be
papers.
required, my lord.
Huh?
May not be required, my lord.
Otherwise, try to see, at least you take out a letter notice by registered post.
Lord, notice is served, my lord.
Correct, counsel. What I'm saying, at hearing, suppose we realize there will be a waste of time, you at least send a communication by registered post stating so and so matter, you have not put in appearance, so that maybe somebody may appear. You
My-
also see at your end, madam,
Please.
in case your officers,
I will check with them. If they
this
have
is-
any connect with them.
so let the service be complete.
Yes. Yes.
Yes,
My
really,
lord, serial number 53, my lord.
just wait.
May request for
On.
date, madam.
7th.
Yes.
Grateful.
Grateful.
Yes,
Serial number 53, my lords.
yes.
I seek for a short adjournment, my lords.
At request, relist the matter on.
7th of November.
Yes,
My lord, interim order may be continued, my lord.
the grant is extended to the next.
56 and 57 for FCC,
Much obliged.
see the papers day before.
You have informed the other side.
Subramania R.
56 and 57, relist.
7th of November. Page number 14, 58 and 59. Page number 15, 62, 60 to 62. List 2, page number 1, 1 to 4. Page number 2, 5 to 7. Page number 3, 8 to 11. Page number 4, 12 to 18.
Yes. You have informed. Yes. Relist the matter on
Fourth.
fourth. Yes.
Serial number 40, my lord.
Huh.
I think the other side has moved it. I appear for the petitioner.
Huh.
It's only requesting for equal pay for equal work, my lord.
Correct. So you want it to be
They
taken.
have sought for an adjournment. Any date, my lord, sir, please,
You have given a date.
so that they will file their objections.
Yes.
Next one, fresh matter, serial number 1, 10.30.A.M. Unni Krishnan, Pramod.
I appear for the petitioner in this case, my lord. My lord, the matter pertains to non-settlement of EL encashment even
Yes,
after retirement of 10 to 15 years of the petitioners, my lord.
It's
The
a-
matter of similar nature is decided on last Friday, my lord.
Yes,
I may be
yes,
perm-
yes, yes.
Yes, your
Let,
lord.
I think I signed it yesterday. We'll have it
Please.
on Monday.
Please, your lord.
Identical order, isn't it?
Yes, your lordship.
Just, we'll have it on Monday. Please relist the matter in the same stage. Yes. A check mud, HMT.
Number 2,
Great.
FIMG.
Yes, next pass over.
Serial number 3, Putegoda K.
It's for the petitioner.
Take out notice.
Please.
Who
Manoj, may
appears?
I, for the best, KPTCL Manoj.
Huh.
Rakshita DJ.
Huh?
Rakshita DJ is a panel.
Third council.
1 and 2.
Rakshita DJ is directed to accept the notice for the respondents. Yes.
Manoj, may I request for a date, please, Manoj? It's
No,
a matter for promotion. All my
Correct.
juniors are promoted.
Correct, but they have to file their state.
Please, Manoj.
2 weeks admin date.
7th of November.
Yes.
I'm grateful.
4.
The matter pertains to revision of pension. The petitioner is a retired municipal district project manager.
Council Sri Amit Anand Deshpande is directed to accept notice for the respondents. For the respondent number. Now this High Court is not required, is it?
Not required.
Not made a party, man.
But
They are
is
not
employ-
required,
Huh?
Manoj.
They've
Only
not been made a
But
party.
the High Court is the employer, isn't it? In case of some thing, it's better you make the High Court also a party. In case the High Court needs to take a stand because others may be similarly placed, you make them a party.
yes, I'll do that.
Learn also is permitted to array the High Court as an additional party. So Amit Anand Deshpande is directed to accept notice for the newly added respondent. AGA is directed to accept notice for respondents 1 to 5. Relist week after next. Yes,
Amend it.
yes, yes.
5, Nanjareddy PN.
Preparing for
Petitioner is
respondent number 1.
permitted to correct, to amend this.
Only for
Yes.
Madam Milad, correction of date of birth.
What is the procedure? What is the
ಅಲ್ಲ
procedure?
sir, state government ಆದ್ರೆ the act is there in that.
Correct,
there is no consideration.
No,
The other,
can't be, the
No, it can't.
judgment of, can't be minutes, even the
What
manual. 2021-12 SEC.
It has
has
to be done by way of a declaration.
Please, no, that also can't be minutes. Because he is
that-
in the fag end of his retirement.
So that will consider.
that's not.
That will consider. Whether it's a fag and whether there is reasons, that will consider.
But and there is no reasonable documents is also produced, my lords, and in this judgment, it is clearly
I-
held that if there is a cogent evidence also, the court need not be interfered and needs to be rejected in
Correct.
this.
So there are two parts. One is as per relevant regulations
Regulations,
applicable.
5, section 5, clause 2 of the Karnataka State Servant Determination
not a-
Age Act it applicable, my lords, very clear.
Have you adopted?
No, no, not.
No, my lords, this is the act we need. to
No, no,
follow.
I'm just asking.
State government, it is there, I agree. But
For
it is-
BBMP,
Yes.
whether this act is applicable.
I'll
If it is,
just seek
ah,
instructions and I'll make
ah,
my submission.
if
of
it is applicable, then he goes out.
Of course.
Otherwise, the points, second point we'll consider.
Please.
Whether it is at a belated stage, that we'll see.
It's a man and the documents also, the representation which he has given, he has not produced any documents to show that he born on such a date. He has said that my sister is born on such a date, so this needs to be considered.
Let
That is
us-
what the application, mandamus reads me.
Let us see. But you have to also take a stand whether Karnataka state servants determination of
Please,
age act is.
my submission.
Learned counsel for the respondent to file, to take their stand by filing statement of objections. List the matter in B group week after next.
Some date may, because next, ಅಲ್ಲ ಏನಂದ್ರೆ
ಹ್ಮ್.
next
25.
ಅಲ್ಲ correct.
ನೋಡಿ ನೋಡ
ಅಲ್ಲ some date may be, so that
ಕರೆಕ್ಟ್
ಆಗಲ್ಲ
2 weeks ಆದ್ಮೇಲೆ ಡೇಟ್ ಕೊಡಿ 12th of November.
ಒಬ್ಲೇಸ್
ಅಲ್ಲ ಒಂದು ಕೇಳ್ತಾ ಇದ್ದೀನಿ, is it difficult to get matters posted?
ಅಲ್ಲ ಅಲ್ಲ ಈಗ ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲ I want to know,
ಅಲ್ಲ ಇಷ್ಟವರೆಗೂ ಇತ್ತು, ಈಗ ಗೊತ್ತಿಲ್ಲ. We have to see.
I want to know
ಅಲ್ಲ
whether matters will come up on their own or there is some difficulty.
some difficulty.
Then I'll give it.
That is the reason. Oblige.
Not as difficulty as 482. Yes, next.
Oblige.
6. Raghavendra.
Therefore, the dictionary is,
Yes,
dictionary is challenged, the annexure D is, annexure D is the endorsement is challenged.
now they dismissed you only because of the criminal complaint.
The,
No separate inquiry.
no separate inquiry. Criminal case is also quashed, madam, and endorsement is given by only that. ಅದರಲ್ಲಿ ಕೆಲಸಕ್ಕೆ reinstatement ಮಾಡಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಎಂಡಾರ್ಸ್ಮೆಂಟ್.
Let us see, you take out notice. Commissioner Mysore Mahanagara Palike. Manjunath. Vivekananda. Council Miss MP Gita Devi is directed to accept notice for the third respondent. AGA directed to accept notice for respondent 1 and 2. List after 2 weeks in orders list. Now just show the termination order. You're saying only on the
Only.
basis of
Complaint.
pendency, no separate
No
inquiry.
separate inquiry.
Just take me to your termination notice.
This is annexure A, madam. ನಾನು ಪ್ಯಾರಾ 2 ಮೇಡಮ್.
Yes,
ಸದರಿ ದಿನಾಂಕ 16/10/2004 ಮಾನ್ಯ ಪ್ರಾದೇಶಿಕ ಆಯುಕ್ತರು ಮಹಾನಗರ ನಿರ್ದೇಶಕರು ಮೈಸೂರು ಅವರು ನೀಡಿರುವ ದೂರಿನನ್ವಯ ಮೈಸೂರು ನಗರದ ನಜರಾಬಾದ್ ಪೊಲೀಸರಲ್ಲಿ ಠಾಣಾ ಸಂಖ್ಯೆ ಪ್ರಿವೆನ್ಷನ್ ಆಫ್ ಡ್ಯಾಮೇಜಸ್ ಟು ಪಬ್ಲಿಕ್ ಪ್ರಾಪರ್ಟಿ ಕೇಸ್ನಲ್ಲಿ ಆರೋಪಿಯನ್ನಾಗಿ ಮಾಡಿ ಆರೋಪಿ ಸಂಖ್ಯೆ 15 ದಿನಾಂಕ 16/10 ಪೊಲೀಸರು ದಸ್ತಗಿರಿ ಮಾಡಿ ಬಂಧನಕ್ಕೆ ಒಳಪಡಿಸಿರುತ್ತಾರೆ. ಹಿರೇಗೌಡ ಅವರು ಸರ್ಕಾರಿ ಆದೇಶ ಸಂಖ್ಯೆ 5 ಆದೇಶದಿಂದ ಮೈಸೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ವಾಣಿ ವಿಲಾಸ ನೀರು ಸರಬರಾಜು ವಿಭಾಗದಲ್ಲಿ ಸಮಾನ ಕೆಲಸಕ್ಕೆ ಸಮಾನ ವೇತನದಲ್ಲಿ ವಾಲ್ವ್ಮ್ಯಾನ್ ಆಗಿ
no, but you are not a regular employee. So list after 2 weeks, date good. You
Date
serve
ma-
copy on the standing council.
Stuff November.
ಡೇಟ್
ಕೊಟ್ಟಿದೆ.
Stuff November. 7. Rather,
ಇದೇನು ನಮ್ದು?
ಬ್ಯಾಂಕ್ ಸರ್ಫೇಸ್ ಯಾಕೆ ಮೇಲೆ
It has to go before another bench. List before registry to ಕೇಳಿ ಹೆಂಗ್ ಬಂತು ಅಲ್ಲ ಕೇಳಿ list before appropriate bench. Forthwith. Yes.
8. Mamta ji ke ಏನು ಮಾಡಿ
Then for the respondent. This matter where my lords has held an interim order in other connected matters, my lords. It's archaeological department, very true.
There is an interim order.
Please, my lords, in writ petition 13164 and also on 15/10/2024, the court has granted an interim order.
Counsel for the petitioner submits that in WP 2643 of 2024, in identical circumstances, this court has passed an interim order. Full stop. The interim order passed in The above mentioned petition reads as follows. In light of the submission that the present matter is identical to the matter above mentioned, there would be an interim order to the effect that the temporary status within bracket group B of the petitioner to be protected, subject to further orders to be passed. List along with WP numbers so and so. Otherwise,
Sir. There are many other cases also, my lords. I'll just hand over those cases to the
give
court
it.
officer, please.
give it.
Even in serial number 18, my lords, today it is listed.
Serial number
18, my lords. DVS and Union of India has to produce a report, my lords, on my lord's order, that the report is awaiting from the department, my lords, so need some more time.
So list along with.
Please, my lords, serial number 18
You
also.
give the other.
Please,
numbers
I'll
also.
just ascertain and I'll produce.
Yes.
9. Suraj 9.
Because the petitioner is questioning the inaction of the respondent number 1 and concluding the appointment.
AGA. is
One and
directed-
two.
Who appears?
My lords, for respondent number 3, Srimati Belli Ravi Varma.
Huh?
Belli Ravi.
Council so and so is directed to accept notice for respondent number 3, AGA for 1 and 2. List the matter in orders list next week.
Those are sought for dispensation of annexure A and B.
IA, but dispensation is allowed. And the petitioner dispense with the production of typed copy of annexure B. A and B.
Please. My lord, certified copy of A and type
Original
copy.
or certified copy of A and B.
My lord, certified
IA
copy
1
of
of
A and type
24.
copy of B.
IA 2 of 24, production of typed copy of B. Both are allowed.
10. Srinivas. Srinivas.
Petitioner by it's sought for the mandamus to direct the fourth and fifth respondent to pay the salary, my lord. They have not paid the salary,
They have not paid.
not paid, my lord. That's why
AGA
mandamus. And also I will take notice to the standing council, my lord, Soumya.
and land council.
Yes.
You can appear.
Yes.
Land council MS Devraj directed to accept notice for respondent.
Even CEO was directed the panchayat authorities, my lord, as for annexure A. They have not taken any action.
2-5. AGA is directed to accept notice for
Kindly fix
respondent
the
number
date,
1.
my lord. 23ರಿಂದ
matter.
ಏನು ಬರ್ತಾ ಇಲ್ಲ ಸ್ವಲ್ಪ.
It's the matter in the orders list on
10 days.
correct 10 days. list. He is not paid salary, so you will have to take personal interest and see what can be done.
Much
Orders
obliged.
list.
Much obliged.
11. Subramania R.
Take out notice. Who appears?
Pavan.
BBMP. Manjunath. Pavan Kumar.
Srinivas Gowda
Pavan
also.
Kumar is directed to accept notice for respondent 2 and 3. AGA for the first respondent. List week after next in B group. Date code.
7.
Let them take their stand.
Please.
12. Satish K.
For the petitioner.
Hmm.
Lord,
Take out notice.
short question is, my lord, I have completed 3 years in the.
Correct. So that let us see.
Please.
So you say there's already a government order which says 3 can be considered. You take out note.
There is a government order, my lord, is of the year 1982.
Hmm.
Thereafter, my lord, from time to time, my lord, the state has issued a government order. Wherever it is backlog, Lord, it should be reduced. Page 36 is one such order.
Let us see.
Please,
Karnataka Housing Board. Manjunath.
Housing Board.
So and so is directed to accept notice for the respondent. List the matter week after next in B group. Date code.
Da-
13.
I shall serve on, my lord.
Yes, yes. That will tell. We'll just find out from who is in the list.
You have a petitioner, your
I
honor.
am KVAter. I am for respondent 5. Copy has not been served upon me, ma'am.
Yes, sir.
served on 21st month.
I have not been intimated. my lord.
There is the
ಆಯ್ತು.
urgency in this matter.
ಆಯ್ತು, ಇನ್ನೊಂದು ಕೊಡಿ. We'll have it tomorrow or day after tomorrow.
May kindly be taken up in the next week, my lord, because I will have to file the detailed objections.
No, my lord, this is the urgent matter, my lord. They
Give
are
him-
dismissed.
Copy is not yet served upon me, my lord.
Today I'll serve
Give
the
him a
copy
copy.
tomorrow, my lord.
We'll have it on Monday.
Tuesday, my lord, because I will have to consult my client. I will have to file a detailed objections. May kindly be taken up for Tuesday, my lord.
We'll have it on Tuesday. Let us.
Tuesday, my lord, and let my London friends serve the copy today only, my lord.
You serve it today itself.
My lord, there is the urgency, my lord. For
I'll
that reason,
consider-
my lord, tomorrow it may be taken, my lord, because they
Without it,
enquired the entire proceeding on single day, my lord.
that
They sitting the single day, they are concluding the enquiry.
we will take note of what stand they place
My lord,
and we'll give you relief. You must have patience.
No, my lord, the inquiry, I'm instructed that the inquiry has been taken in the way known to law. I will file detailed objection.
Correct. Their contention is it was concluded only in.
No,
one day.
it is wrong, my lord.
So you place the.
Yes, I
record.
did, this is what I'm taking time, my lord. I'm praying for time for that reason. I will have to place all the documents to show as to how the inquiry has been conducted. So let my London friends have the copy today only, my lord.
Can I submit, my lord, one point, my lord? They are issued the articles of charges under the Karnataka Education Act 1980. They are dismissed the employee by invoking the three different enactments, my lord. That is not permissible.
I'll examine that. I'll examine.
My lord, they have invoked the three enactments, my lord. In the three different enactments, my lord, there is a three different appeal provisions. But they are, my lord, without due process of law, without application of mind, they are dismissed the employee. my lord.
Saturday morning, Sunday.
For that reason, my lord, he is on street, my lord, now. My lord, there is a ambiguity with regard to filing
We'll
of the.
I will accentuate my arguments along with the documents, my lord.
We'll consider, list the matter in the orders list on Tuesday.
Tuesday, my lord, and but I may be permitted to serve the copy today only. Yes.
Is to be served on the council for respondent forthwith. Who are the other respondents?
I am for respondent number 5.
One private respondent is there, man.
Huh.
Two private respondents are there, management and headmaster.
The relief has been sought against me, my lord. I am respondent number 5.
AG is directed. AG is directed to accept notice for respondent 1 and 2. Now you appear for
I am respondent number 5.
3 and 4. 3 and 4.
3 and 4 of sons.
Government,
Emergent notice to
director
respondent
and
3 and 4.
director vice chancellor.
Interim matter may consider,
Emergent
my lord.
3, 4, 3, 4 and 6 emergent notice. Petitioner is permitted to take out notice by way of hand summons as well. Consideration of interim prayers kept open. List the matter in the orders list on Tuesday. Copies of the petition to be served today itself.
Obliged.
14.
Much obliged. Your Honor.
Petitioner.
The petitioner, my lord, is the legal representative of a deceased employee of Mysore City Corporation, my lord, sir.
Take out
That's-
notice.
My lords, covered by the
Yes, yes.
decision. Annexure, yes, my lords,
I saw
annexure R, page two
I
fifty-six.
saw it. Let us.
My lords, for respondent number 4, my lords, Madam Geeta Devi Papana appears.
Alert council, Geeta Devi Papana is directed to accept.
For other
notice of
respondents, 1, 2, 3, and 5 statement.
EGA for 1 to 3, 1, 2, 3 and 5.
5.
List the matter in the orders list on 30th.
15.
30th, ಸ್ವಲ್ಪ they may require some more time
Lords,
to verify. to
Covers.
verify.
please,
7th,
please,
let them just verify.
please.
Once they take the, then they nothing survives.
Yes, my lords, because similar placed employee have been considered. And they have also passed orders, complying the orders of the honorable.
15. Sadashiva A.
Here for the petitioner, my lord, I'm seeking appointment on the ground of compassionate
Court
appointment.
notice.
Please, my lord.
APTCL Chescom. For KPTCL. Third Council MC Nagashri is directed to accept notice for first respondent. Chescom. MC Nagashri for the respondent 1 and 2. This is the matter week after next in B group. Yes.
Grateful, my lord.
7th. 16. Therapist code.
Petitioner, my lord, is requesting for his appointment to be considered.
Take out notice. AG is directed to accept notice respondent 1 and 2. Vivekananda.
Or Sharad Gowda GB is also. In similar matter, he is appealing.
For respondent number 3. Yes.
In this, they may have to file objection. In this.
Yes.
Order serial number 17, Umesh PN.
Petitioner in this case.
Yesterday's matter, my lords, was adjourned for production of representation with regard to succession certificate.
Kiran Kumar.
Just read it.
Is the representative ಕುಟುಂಬದ ಪಿಂಚಣಿ ಮಂಜೂರು ಮಾಡುವ ಕುರಿತು ನಾನು ಶ್ರೀಮತಿ ವನಜಾಕ್ಷಿ ಎಂ ನಾಯಕ್ ವಿನಂತಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ನನ್ನ ಪತಿಯವರಾದ ಮಾರುತಿ ಎಲ್ ನಾಯಕ್ ಇಸಿ ನಂಬರ್ ಸೋನ್ಸೋ ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ದಿನಾಂಕ 12/5/2017 ನಿಧನ ಹೊಂದಿರುತ್ತಾರೆ. ಈಗ ನನಗೆ ವಯೋಸಹಜ ಅನಾರೋಗ್ಯದಿಂದ ಬಳಲುತ್ತಿದ್ದೇನೆ. ಆರ್ಥಿಕ ಸಹಾಯದ ಅವಶ್ಯಕತೆ ಇದೆ. ಆದುದರಿಂದ ನನಗೆ ಪಿಂಚಣಿಯನ್ನು ಮಂಜೂರು ಮಾಡಬೇಕೆಂದು ಕಳಕಳಿಯಿಂದ ಕೇಳಿಕೊಳ್ಳುತ್ತೇನೆ. ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕಾನೂನು ರೀತಿಯಲ್ಲಿ ಸಲ್ಲಿಸಬೇಕಾಗಿರುವ ದಾಖಲಾತಿಗಳನ್ನು ಸಲ್ಲಿಸಿರುತ್ತೇನೆ. ಮತ್ತೊಮ್ಮೆ ದಯಮಾಡಿ ಪಿಂಚಣಿಯನ್ನು ಮಂಜೂರು ಮಾಡಬೇಕೆಂದು ಕೇಳಿಕೊಳ್ಳುತ್ತೇನೆ.
Fixation of pension.
Pension and there are other arrears, my lords, to be paid by the respondents. Lords, initially I made a representation, my lord. They issued an endorsement stating that you are not a nominee in the service records. So I approached the civil court, my lords, to obtain the succession certificate. Lords, wherein the petition, my lords, I specifically stated the deceased has one more wife and there was a compromise between the husband and the other wife, and that compromise petition was also produced before the trial court. But considering all these facts, my lords, the trial court has granted succession certificate in my favor, my lords. So this representation came to be made, my lord, along with the copy of the judgment of succession P&SC case, my lord. The respondent has issued an endorsement at Annexure A stating that he is not party to the proceedings and also the other wife is not party to the proceedings. That cannot be a stand of the respondent, my lords, because respondent was not a necessary party before the trial court. It is against the debt, my lords, which will be made as a schedule. In respect of that, my lords, a certificate will be issued by the trial court, my lords. And the respondent is bound by that certificate, my lords. It is a conclusive proof, my lords, as per section 381 of Indian Succession Act, my lord.
Indian succession. Just read.
Effect of certificate, subject to provisions of.
There appears to be some mistake in printing his name in the cause list. We'll ask the office to put the full name and have it tomorrow.
Please.
No, but now what is the relief you are seeking? That to consider?
My lords,
Take note
actually,
of
my lords, the request is for release of the amount, but unless and until I produce a succession certificate, they cannot release that amount, my lords. So for getting a succession certificate, there is an order, my lords. There is an order stating that I need to pay stamp duty. For paying stamp duty, I need the arrears of amount which is pending before them, which they are supposed to pay the deceased. So unless and until they give that details of the arrears, my lords, I cannot pay the stamp duty. Once they give that details, my lords.
So what we'll do, you give a representation to KPTCL today.
Please.
Today, mentioning that the matter is pending and you seek for the direction to that effect next week.
Please.
I'll have it after 10 days.
Please.
And I'll consider.
That would be.
Office to show the name of the counsel representing the respondent as. Relist the matter. 2 weeks, 1 day. Sixth,
Please,
you
much,
give one representation
please,
and then you file an IA for direction or an amendment, I'll consider.
please, please.
18,
Needs to be connected with serial number 8, my lords.
Same, is it?
Same, my lords. They need to file a report now,
List
wait.
along with serial number 8.
Please.
19,
Lord, I appear for R4 and 5. Readings are complete. I request for a week's accommodation.
This is reduction of salary.
Deduction of
Salary during the COVID time. Despite the circular by Visheshraya Technology University and also AICT. During the COVID time, no reduction is permitted.
no deduction is permitted.
Yes, 50% salary they have.
My colleague is handling this. Therefore,
We will take it.
Any
but
date next.
That's the case.
Certainly.
Relist the matter on.
In fact, RV Engineering College,
Uh,
similar incident has happened. We filed a writ petition, page 88. They said will not deduct it. Whatever it has been deducted, will refund. Page 88.
They're deducting on what ground? That they are
COVID, my lord. But they work full time.
relist the matter in the same stage on next week. Fourth,
Please, publish.
just have a look at that order in.
That
20, Anil Kumar. Umapati, yes.
I am for the respond number 4 and 5. We have filed the wakalat, madam. My name is not shown in the cause list.
Office to show the name of learned counsel so and so as representing respondent
4 and 5, madam.
4 and 5.
We may be permitted to file a detailed statement of objection by the next date of it.
Now, what about the other respondents?
Other respondent, Chief Executive Officer and Executive Officer. Jilla Panchayat Tumkur, Nagarajappa is appearing, my lord, standing counsel for Tumkur.
For respondent 2 and
3, my lord.
learned counsel Shri A. Nagarajappa is directed to accept notice for respondent 2 and 3. Learned counsel for respondents 4 and 5 submit statement of objections would be filed. Relist the matter on. Now, what is the matter?
Dismissal, my lord.
On what ground?
Without given second show cause notice. All 4 charges are not yet been proved. No inquiry, my lord, conducted in terms of the 2020 rules. No witnesses were examined. No documents are produced before the inquiry officer. Ultimately, the charges have been proved. In only one charges have been proved. Thereafter, no notice has been issued to the petitioner. The order of dismissal has been passed. Earlier also, dismissal order was passed. This honorable court has set aside and liberty was given to the Gram Panchayat to conduct an inquiry in accordance with law. Thereafter, my lord, the order of suspension has been passed. Ultimately, he is out of service for last 3-4 years.
Relist the matter on. When do you want?
20, madam. 2 after 2 weeks, madam. Any date after 2 weeks, madam.
12th of November in same stage.
Interim order.
Let us see. Let him take his stand.
Please, madam.
On that day, I'll keep it in the orders.
Already there is an
Order
interim
please.
order.
There is an interim order. There is already an interim order.
Please,
Stay up the impugned notification.
To list the matter, then the interim order earlier granted is extended till the next day. Yes.
Much short.
21. Srinivas V.
ಬಂದಿದ್ಯಾ ಪಾಸ್
22, Srinivasa K.
Lord, I appear for the petitioner. Petitioner, my lord, was working, my lord, as a junior lineman, was appointed, my lord, in accordance with the procedures, my lord, by the respondents by following the selection process in 2017. My lord, he had worked till 2024, my lord, during which period it was alleged by the respondents that the
medical certificate that was produced by the petitioner at the time of his selection regarding his hearing impairment is the bogus. My lord, he was referred to medical boards. My lord, medical boards gave, my lord, a different, my lord, the percentage of the disability. So without inquiry, my lord, without any opportunity to the petitioner, my lord, he was, my lord, dismissed from service. My lord, the said, my lord, order of dismissal, my lord, is unsustainable for the reason that in similar case, my lord, Dissambu court has held that an employee cannot be dismissed, particularly when he is a permanent employee and when he has been confirmed in the service. They have produced the copy of the order passed by the Sambu court, my lord, in similar cases at annexure P, my lord, W, page 68. Division bench, my lord, has categorically held, irrespective of the allegation that is made, an opportunity of hearing and inquiry should be, my lord, initiated against the delinquent employee. Here in the case, my lord, no such opportunity has been given. And straight away, my lord, without even disclosing the, my lord, the medical report, my lord, given by the board, my lord, he has been, my lord, dismissed from service, while annexure V, my lord, dated 1/8/2024. The said out, my lord, my lord, has been passed behind the back of the petitioner, my lord, without, my lord, giving an opportunity of hearing. The same, my lord, is liable to be state law.
No inquiry.
No inquiry was held. Admittedly, my lord, he is a permanent employee. His probationary was declared. Pay fixation was also made. Subsequently, after lapse of, my lord, 7 years, my lord, the respondents contend that the medical certificate submitted by him at the time of appointment in 2017 is a bogus. Lord, the medical report, my lord, which he had produced at the time of his appointment was also given by the doctor, my lord, a district surgeon, after examining the petitioner. He had assessed the disability of the petitioner at 60%. Subsequently, my lord, he had also stated that there is likelihood of the improvement in the hearing capacity of the petitioner. So without taking note of those aspects, my lord, the respondent, my lord, has passed.
You serve the standing counsel.
Please.
Discount. Standing counsel H-Chandrachud is directed to accept notice of respondents 1, 2, 3. Serve a copy today itself.
Please, madam.
This is the matter in the orders list next week, please. 30th.
Please. 23. Okay. Lord, this is a case, my lord, wherein the petitioner is a retired junior engineer. My lord, after his retirement, my lord, the respondents, my lord, on the alleged ground that his pay fixation was done wrongly in the year 2008.
So what is the office objection?
Office objection, my lord, I have not mentioned the annexure in the prayer column.
Petitioner,
I will comply.
petitioner is permitted to comply with the office objection as seal number 1 in court. What is the main matter?
Matter is, my lord, the recovery, my lord, has been done from out of the terminal benefits of the petitioner, my lord, contrary to the judgment of the Honorable Supreme Court in Mashia's case. Lord, the petitioner, my lord, has retired on 30/6/2024, and the recovery has been made, my lord, from out of his the unleave encashment, which is totally impermissible. Further, my lord, no opportunity, my lord, has been given before reduction of the basic of the petitioner. Annexure C and D, my lord, are the impugned orders, by which, my lord, the basic of the petitioner has been reduced, my lord, from 1,10,100 to 1,08,100. So such a, my lord, exercise cannot be done, even if there is, my lord, it's a lapses on the part of the administrative authorities. So I am not, my lord, I have not misrepresented, or I have no role, my lord, in the pay fixation.
Manjunath, Discom KPPC. H-Chandrachud is directed to accept notice to respond 1 and 2. This is the matter in the orders list. 30th.
Great.
You serve copy today.
I will, please. 24, Srinivas B.
Lord, I appear for petitioner. Lord,
Office objection.
office objections in my case are very minor. My lord, verifying affidavit ಅಲ್ಲಿ ಎಷ್ಟು ಪ್ಯಾರ ಇದೆ ಅಂತ ಫಿಲ್ ಅಪ್ ಮಾಡಿಲ್ಲ. ಆಮೇಲೆ ಇನ್ನೊಂದ್ ಕಡೆ ಸೈನ್ ಬಿಟ್ಟೋಗಿದೆ. ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ ಒಂದು ಸೈನ್ ಬಿಟ್ಟೋಗಿದೆ. So that is the office objection. I will comply now itself, my lord.
Petitioner is permitted to comply with the office objection
my lord, the petitioner have been dismissed from the service on the ground that he has been convicted in a case for, my lord, where Lokayukta have initiated, in ACB have initiated, he was laid a trap, my lord. In a trap, a proceedings was initiated under section 13(1)(d) and 13(2) of the Prevention of Corruption Act, and in which he has been convicted. And now, my lord, as against the conviction, he has filed an appeal before this honorable court, and this honorable court have stayed the proceedings, which is at Annexure D, my lord. Conviction, my lord, sentence have been suspended. Under those circumstances, my lord, on the same charges, departmental inquiry was also initiated. Apart from giving articles of charges, nothing proceeded in the departmental inquiry proceedings. It remained as it is till the conviction order is passed. Now, my lord, all of a sudden excising the powers under section rule 14(1) of the CCA rules, my lord, he has dismissed the petitioner without issuing a notice also. Even one show cause notice is also not issued. It is in complete violation of principles of natural justice.
Rule
14(1), my lord. 14(1) of the CCA rules. Lord, it says it is only if the conviction is based on an inquiry which is, may I read?
14(1) now.
CCA, my lord. My lord, special procedure in certain cases. Page number 30, maybe page number 30, my lord. Notwithstanding anything contained where a penalty is imposed on a government servant on the ground of conduct which has led to his conviction on a criminal charge. My lord, first there should be a penalty and on his conduct, and that has led him to the conviction. Then this special provision can be invoked. Here that is not the case. My lord, exactly on the similar lines, my lord, Punjab and Haryana High Court have quashed the proceedings, my lord. I have quashed the same order, my lord, similar order. Next.
No, what is this rule? What is the effect of Rule 14?
Notwithstanding anything contained in Rule 11 to 13, that is the departmental inquiry procedures, my lord. Where a penalty is imposed on a government servant on the ground of conduct, there should be a penalty, my lord, on the ground of his conduct, which has led to his conviction on a criminal charge. First penalty agi, ಆ ground ಮೇಲೆ ಅವನ ಮೇಲೆ criminal case ಇದ್ದು ಅದರಲ್ಲಿ criminal charge on a criminal conviction ಆಗಿದ್ರೆ on that criminal charge he can be discharged. Even for that also a notice should be issued, my lord. That is where the governor, next, my lord, 3, my lord, Rule 3. Where the governor is satisfied that in the interest of security of the state it is not to follow such procedure, the disciplinary authority may pass thereon as it deems fit, provided that the commission shall be consulted before passing such an order. In any case, for such consultation is necessary.
Commission means?
My lord, they should have formed one commission for this type of this thing, my lord. Now, my lord, your lordship may kindly come page number 126, my lord, in the writ petition.
Yes.
ಉಲ್ಲೇಖ 8ರ ಸರ್ಕಾರದ, my lord, last paragraph. I am reading last paragraph, my lord. ಉಲ್ಲೇಖ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ ಸೋಂಟೆ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣ ಸಂಖ್ಯೆ ಅನ್ಯ ನ್ಯಾಯಾಲಯವು ನೌಕರರಿಗೆ ಶಿಕ್ಷೆ ವಿಧಿಸಿ ತೀರ್ಪು ನೀಡಿದ್ದಲ್ಲಿ ಸಂವಿಧಾನದ ಅನುಚ್ಛೇದ ಅಲ್ಲಿ 2ನೇ ಪರಂತು ಸಮರ್ಥನೆ ನೀಡಿರುವ ಕರ್ನಾಟಕ ಸರ್ಕಾರಿ ಸೇವಾ ವರ್ಗೀಕರಣ ನಿಯಮ ನಿಯಮ 11 ಅನ್ವಯ ಕ್ರಿಮಿನಲ್ ಆರೋಪವು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಾಬೀತಾದಂತಹ ಸರ್ಕಾರಿ ನೌಕರರನ್ನು ಸೇವೆಯಿಂದ ವಜಾ ಮಾಡುವ ಅಥವಾ ಸೇವೆಯಿಂದ ತೆಗೆದುಹಾಕುವ ದಂಡನೆ ವಿಧಿಸಬಹುದಾಗಿದೆ. ಇವರ ಆದೇಶ ಸಂಖ್ಯೆ 226 ಸರ್ಕಾರದ ಸುತ್ತೋಲಿನ ಅಂಶಗಳನ್ನು ಪರಿಗಣಿಸಿ ಸದರಿ ನೌಕರರನ್ನು ಸೇವೆಯಿಂದ ವಜಾಗೊಳಿಸುವ ಸೂಕ್ತ ಎಂದು ಅಭಿಪ್ರಾಯಪಟ್ಟು ಈ ಕೆಳಗಿನಂತೆ ಆದೇಶಿಸಿದೆ. ನನಗೊಂದು ಶೋಕಾಸ್ ನೋಟಿಸ್ ಇಲ್ಲ, ಏನೂ ಇಲ್ಲ. ಇಟ್ ಇಸ್ ಪಾಸ್ಟ್ ಕಂಪ್ಲೀಟ್ಲಿ ಇನ್ ವೈಲೇಷನ್ ಆಫ್ ದಿ ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಆಫ್ ನ್ಯಾಚುರಲ್ ಜಸ್ಟಿಸ್. 2 persons were convicted. Other person have been given the duty and he is discharging the duty. He still, I have been dismissed.
Now this has been stayed.
The sentence have been suspended. Suspension of sentence is at Annexure D. My lord, Allahabad High Court judgment Annexure G, exactly on the same grounds. Exactly.
Paragraph.
My lord, paragraph, my lord, your lordship may kindly get the, my lord, the paragraph number 6, page number 130.
What is this? You put it? 311 provides, second proviso is provides for constitution. Provides for you cannot discharge without inquiry. Is it?
Yes, my lord. 311, Constitution of that also. There should be an inquiry before discharging any, my lord, any of the government, because it's a protection given to them.
So where is the order? The point, which paragraph?
My lord, may I take your lordships to the operative portion of that order, my lord? Page number, paragraph number 13, page number 134. Where he was convicted for an offence punishable under 302. My lord, in this case, my lord, in the citation, my lord, he was convicted for 302. On that ground, he was discharged from the duty. Now, my lord, that was called in question before the Allahabad High Court. Therefore, it is clear from the above decision and relevant provision of law that is incumbent upon the authorities to consider the conduct of the employer which has led to his conviction in a criminal charge before imposing any punishment. In the present case, the impugned order passed by the respondent only stated since the petitioner has been convicted in the criminal case, he should be dismissed from service from the date of order of conviction. The respondent number 2 was required to examine the conduct of the petitioner which has led to his conviction before imposing the major punishment upon him. The orders suffer from non-application of mind, shows arbitrary exercise of discretion vested in the respondent number 2 by law. Now, my lord, the provisions of that particular state, my lord, is analogous to 14.1. The provision have been extracted in paragraph number 6, that is page number 130. May I, my lord? It is quoted, my lord, it is quoted. Paragraph number 16, one para ide. Dismissal, removal or reduction in rank of persons employed in civil capabilities under the Union of State. No person who is a member of a civil service of Union or an all India service or a civil service of a state or holds a civil post under the Union or state shall be dismissed or removed by an authority subordinate by which he was appointed. No such person shall be dismissed or removed after an inquiry in which he has been found guilty.
Now you take instructions, but now suppose he is convicted, no doubt. Now when this sentence is suspended and it is done only ipso facto on the basis of the conviction, you will have to take him back. Remaining benefits we will see. Now we will have to stay. Remaining benefits will have to take a stand. Stand as regards now whether is entitled for all benefits or not. That you will have to take your stand. And whether this Allahabad High Court judgment appears to say you have to apply your mind and then look into the judgment of the trial court and then come to a conclusion, A, that you have to do away with the disciplinary proceedings, B, it may not be appropriate to continue in service and then impose that penalty. That's what it appears to be the scope of 14. Yes. Look into it. The petitioner submits that he was terminated from service as per the order dated 29/12/22.
Yes, my lord.
Huh?
Yes, my lord.
At annexure F.
Annexure.
on the ground that he was convicted for the offense in terms of the judgment passed in Special CC 226 of 2018, passed on
10th October 2022.
15th October 22. He submitted that recent judgment of the trial court has been stayed. And the said judgment of the trial court was taken up in appeal, criminal appeal 1820/22.
May I make one small listing, my lord. Sentence have been suspended.
And sentence has been suspended.
Conviction is not stayed, my lord. Sentence have been suspended. Because he sought for conviction stay and that came to be rejected, as against which he went to Supreme Court. Supreme Court have said it was he has withdrawn the petition before the Supreme Court. So therefore, if we use the word that the conviction have been stayed in this interim order, it may not be right. Therefore, I am seeking sentence was suspended. That is the proper word.
Correct, but is that sufficient to give you benefit?
What?
Is that sufficient to give you benefit?
Yes, my lord, because sentence have been suspended, but 14(1), it will never say, my lord, it says the conviction should be based on the previous penalty imposed by the government. Conviction should be based on the previous penalty imposed by the government on the ground of his conduct. Here, it is not the case, my lord.
Anyhow, have a look at it.
One is very clear, my lord. Where?
No, let us see, let us take a stand. Now you take your stand by next week, and page 126, last paragraph, there is some circular referred to by you. You produce that circular and you take your stand. Consideration of interim prayer is kept open. Relist the matter on
6th of May.
12th. No, but now how do you get over the fact that conviction is not suspended?
My lord, merely because just I am convicted, well, sentence is, as on today, my lord, sentence is suspended. My lord, I am
Anyhow, let us see.
suspended, I am bail have been granted. Now, my lord, that doesn't mean that my lord, conviction should be based on the allegation that on my conduct, and the complaint should be by the government. The conviction should, Lord, penalty should lead me to the conviction here. That is not the case here, my lord. If 14(1) is read, it says the penalty imposed by the government should lead me to the conviction. Conviction cannot lead me to the penalty, my lord. What the government is doing, what the impugned order is exactly the reverse of it. Here the conviction leading me to penalty.
No, now the penalty is imposed on the basis of conviction.
My lord,
Penalty is imposed on the basis of his conviction.
on the basis of conviction.
That they say is permissible under 14(1).
That, my lord, that is not, 14(1) doesn't say like that. First, there should be a penalty on the ground of conduct.
Where a penalty is imposed
Yes, my lord.
on a government servant on the ground of conduct which has led to his conviction on a criminal charge. So suppose they were to say that you have been convicted in the criminal case.
Yes, my lord. On the ground that there is a penalty against me.
No, no. On that ground, they impose a penalty of termination.
No, my lord. Here, my lord, may I read one more time? Where a penalty is imposed on a government servant on the ground of conduct which has led to his conviction.
Let us see. You see some other authority.
Penalty, my lord, there,
I get your point. Let us see. So you are saying independent of that, they have to see what is your conduct
yes.
and taking note of such conduct which has led to
And there should
conviction.
be a report of the commission also. That giving me the job is a threat to security of the government. There should be a report of the commission also.
In terms of
Nothing
the
is
proviso.
there. Nothing.
In terms of the proviso.
In terms of the proviso. That is
Examine.
also not there.
Examine. See any other authorities also.
Yes, madam.
Relist the matter on. Yes.
Well, in the meantime, I am permitted to complain. Now it's office objection.
Petitioners permitted to comply with office objection.
Yeah, seat number 25 or 26, BK Narayan Swamy.
Regarding refixation of the pension from the date of appointment till retirement. He is retired on 2006, therefore some urgency. Government.
You have to accept notice for all the respondents.
Well, reply is filed already.
Huh?
Already government objection reply is filed.
It says served.
Hmm,
You
served.
appear for all the respondents.
Yes.
AGA is directed to accept notice for all the respondents. Yes, what is the stand? You have filed objections.
Already filed the objections, but W writ appeal is pending in the 2476 by 2015. Given the stay of the writ appeal. At the case you have to ongoing, you have not fulfilled the government.
Writ appeal?
Writ appeal is pending to writ appeal 2476 by 15
Regarding?
regarding a stay.
No, writ appeal against?
What happens, my lords? This court has directed to fix the pay from the date of appointment. Writ petition allowed, writ appeal also allowed. They went to Supreme Court. Supreme Court, writ appeal also dismissed, Supreme Court also, it is confirmed the order of single judge. Payment of the, computing the pensionary benefits from the date of appointment itself. Finally, a ordinance has been issued. That enactment has been challenged by the petitioners. Enactment also has been quashed. Against that order, they filed appeal. Appeal, interim order has been granted, subject to condition. Let them pay, fix and pay the pension from the date of appointment itself as per the orders of this honorable court. We will consider the petition that is pending. That is why I am asking, wherever in view of the interim order only of the appeal, let them continue to pay, fix and pay the pension.
Where is the interim order?
Well, it's interim order. Copy. Interim order, copy. Last page. Order ಆಗಿರೋ ಕಾಪಿ ಇದೆಯಾ? Yes, sir. Court. ಕರೆಕ್ಟ್ ನಾವು ಸ್ಟೇ ಇದೆ ಅಂತ ಹೇಳ್ತಿದೀವಿ, ನೀವು ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಿದ್ದೀವಿ. ಅದೇ ಓದ್ತಾ ಇದ್ದೀವಿ. ಇದ್ರೆ ಕೊಡಿ. ಇಲ್ಲ ಕಾಪಿ ಇಲ್ಲ.
So the pension is required to be continued to be paid as was paid.
Please.
Now you are paid.
In this case also,
Hmm.
the petition, after the orders of the honorable court, they have fixed the pensionary benefits.
They fixed the pension.
Please, my lords. Thereafter, they have stopped in view of the enactment issued by the government. Annexure. That's annexure B at page number 67. pursuant to the orders of this honorable court.
What happened before in the first round of litigation? The validity of the act was challenged.
Challenge.
Ah.
It has been quashed, the act has been quashed.
Set aside.
Set aside. Set aside, that is, I have produced that copy also, my lords. It is under annexure.
Now, what do you say regarding the interim order in the writ appeal? State.
My lord.
Interim order in the writ appeal. Says so far as retired employees are concerned, Advocate General submits that the pension that they are getting shall be continued to be paid to them. What do you say regarding that?
Regarding the condone of delay of the writ appeal dismissed for the 83 page number. Page number 83, writ appeal is delay condoned, the special leave petitioner dismissed, the government filed. After the annexers, J 204.
No, just have a look at this. In the code. The last 3 lines marked in pencil. You find out in terms of that,
Yes, ma'am.
you may have to comply with by paying them pension.
Yes.
I'll have it on Monday. Only on that short point. We will not enter into the merits. But it is a submission in terms of the order in the writ appeal. By virtue of the statement made, they will continue to pay the pension as was last being paid. And that will have to be done in the disposal of the writ appeal.
However, it is subject to result of writ appeal pending. In my case also, lords kindly fix the condition. However, it is subject to result of writ appeal.
I'll have it on Monday.
Yes,
Submission.
The subject to condition of the pass of annexer J is have to the same condition is apply for this.
Annexure
we
J,
have
they have
pending-
rejected totally. They have not scattered that writ appeal is
I see
pending.
Monday. I'll have it on Monday.
They have to say,
Could counsel for the petitioner would submit that in terms of the interim order passed in WA 2476 of 2015, petitioner was similarly placed is required to be paid a pension as was being paid. Reliance is placed on the interim order passed in the writ appeal on 27/11/2015. Government to take stand regarding the submission.
one more minute.
Submission of the
Annexure H.
petitioner. Just 1 minute. Submission of the petitioner that they are entitled for payment of pension on parity in terms of the order in the writ appeal. Annexure.
Annexure H, there is already a direction of the sample code.
Page
200. 200. After recording after submission made by the government,
page 200. There is already a direction in WP 38443 of 2015 at para 7. Learned counsel for the petitioner also relies on the direction contained in WP 38443 of 2015, disposed of on 9th March 2020, wherein the learned single judge had disposed of the writ petition, directing the respondents to pay retiral benefits to the petitioner in accordance with the undertaking made and recorded by the division bench on 27/11/2015. Order has been referred to above. After the writ appeal order, He already has the direction by virtue of order of the single judge. So then nothing. On Monday I'll pass orders, but just verify. List the matter. The orders list on Monday. So in terms of the single judge's order and the interim order and the writ appeal, he has to be settled his pensionary benefit that would be subject to the outcome of the eventual writ appeal. Yes.
27, Satish K.
Appearing for petitioners, my lord. Matter pertains to regularization and consequently I'm seeking for retirement benefits, my lord. My request for pension and pensionary benefits were denied on the ground that we were brought under Daily Wage Employees Act, my lord. My lord, Annexure Q, page 93, is covered by your lordship's decision, my lord.
Annexure
Q, page 93.
Now who's answering respondent? Annexure?
Annexure Q, page 93, my lord. Five, pretty question. Para 10.
You're similarly placed. Huh? You're similarly placed.
Same relief. I appear for the petitioner.
Annexure Q, you are similarly placed.
May not be me.
Huh?
May not be me. Lord, I cannot say that, Lord, I am similarly situated as that of Lord petitioners in Annexure Q. Lord, somewhat similar situation, Lord, in respect of MUDA employees.
Recommendation is similarly made by MUDA to the government.
Recommendation is not there.
Is not there.
Not there.
So then it will require some statement by them.
Yes, Lord, I would say that Lord, it is not per se covered. Lord, we are similarly situated as that of Lord petitioners in MB Narayan Gowda. However, Lord, there is no recommendation by the authorities, and Lord, another dissimilarity is Lord, we have been brought under the Lord Welfare Act by the authority itself. Therefore, Lord,
then let them complete their pleading.
Yes, the statement by the government as well as Lord MUDA
Statement of objections to be filed by respondent number 2 as well as the state within 10 days.
Lord, my learned friend has filed the reply.
Who? Vivekananda.
Yes,
Mr. P.P. Vivekananda has filed the reply.
AG, state to file their statement of objection. Date good. 12th of November. Yes.
Please.
Lordship, the connected matter.
Now that other earlier order has attained finality, they have complied, is it?
They have complied. All of them were regularized and my lord, pension is settled. Pursuant to my lord's decision, my lord,
yes.
They did not test the order. They have complied.
Yes.
Lordship, in the connected matter. We have given on this, we have given many representation before the competent authority. Till then, they have not, in the 2016 itself.
Similarly placed.
Please, my lord.
There, my lord, provision of the Welfare
section-
Act
Huh.
is under challenge. State has to answer that, my lord.
Why is it tagged along with this? Has to be separately dealt with.
But,
Hmm.
same parties, my lord,
Same parties.
same parties.
Hmm.
But there is a mistake on my part, my lord. They did not disclose about the filing of
Earlier
petition in the
petition.
connected.
So both have to be decided together.
Please, ma'am.
Yes.
If, my lord, the second writ petition is decided, my writ petition would go along with that, my lord. If
Statement of objections, they are filed in your matter.
Yes, my lord, we have filed.
They are filed.
Please,
Both.
both now.
What about government?
Government has not filed.
In 27.1, government to file their statement of objection within 10 days, list on so and so. List the matter in B group. It requires hearing. Yes, next.
28. 28.
I appeal for the respondent.
for the petitioner.
I'm sorry, my lords, I was not there on the last occasion. 28, I'll see it. I appear for respondents 2 to 6. The respondent is an aided institution in Tumkur, vocational center. It's a very old institution. Unfortunately, some issues have cropped up. Earlier, this honorable court had passed an order that back wages have to be paid, and the state government has made it good for a particular portion of it. It's an aided institution. Now subsequently, he was under suspension. Unfortunately, they did not conduct an inquiry. I have told my learned friend Monday, the bishop has met the delinquent in Dharwad. He is in Dharwad now. But he is adamant that let the honorable court pass an order. The institution wants to settle the matter. Kindly have it on next Monday. The bishop is in Dharwad, in-charge bishop. The office bearers have taken charge on this Friday, new office bearers. I will come back with the proposal on Monday. I'm sorry, I'm
Let
taking
us,
time.
let us.
Left to myself.
Calculation ಮಾಡ್ಬೇಕು ಸ್ವಲ್ಪ
ಇಲ್ಲ, ಒಂದ್ ನಿಮಿಷ. Left to myself, my lord, absolutely no objection. But my learned friend, my lord, is taking time. This is the fifth or sixth time.
reinstatement ಗೆ ನಾನು ಟ್ರೈ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. He is retiring in December. We want to reinstate him. Before that. ಅದಕ್ಕೆ ಮಂಡೇ ತಗೊಳ್ತಾ ಇದ್ದೀನಿ.
Relist learned counsel Shri B.M. Arun requests for a short accommodation stating
some settlement
that respondent is exploring possibility of settlement. Relist the matter in the same stage on Monday.
Please, madam.
urgent. B group matters. Bill number 30.
Hearing for the petition,
For the respondent number 3.
ready, my lord. The matter involved is, my lord, the order passed at an annexure is questioned. The petitioner is was the lecturer in the PU college. That is respondent number 4, my lord. Your lordship may kindly see annexure A.
What is the order you're challenging?
Order challenging is annexure A, my lord, passed by the principal secretary, rejecting the allowing the application of the respondent number 4, Damodar, and dismissing my claim. The tribunal held that the Damodar committed a fraud, and he is earlier appointed in 1997 as a first grade clerk in the sister concern institution, and suppressing that he has come and filed the application for political science this thing in 2009, and he is appointed. Regarding that fraud, and we challenged, my lord, your lordship may kindly see in page number 30, my lord. Page number 30. This honorable court passed the order earlier.
Who are the contesting respondents?
I appear for the contesting respondent, my lords.
Private respondent.
Private respondent. My lords, my simple submission is, my lords, sir, the petitioner claims, my lords, sociology lecturer. The sanctioned post is for political science.
Lords, insofar as sociology lecturer post is concerned, my lords, it is the grant in aid was for appointment of SC and ST, my lords. And accordingly, English and sociology post were filled. Lords, if at all, if she has got any grievance, it should be against, my lords, that reservation and not against, my lords, political science, the post. That is the order passed by the principal secretary.
My lord, the page number 30, kindly look into my.
Now,
Number 30, this honorable.
petitioner, my lords, don't challenge.
Idu page number 30. This honorable court in WP 36,862,2009 passed the following order. Your lordship may kindly say in paragraph 2 mile discussing all the point, paragraph 2 of the said judgment in 32. There can be no doubt that the petitioner has an alternative and effective remedy filing the appeal under section 130 of the Act for short the Act in view of the matter. State of Karnataka by the Secretary, Primary and Secondary Education Department, Bangalore, being the appellate authority is directed to treat this petition as an appeal under section 130 of the Act and pass orders in accordance with law after extending reasonable opportunity to hearing the parties. It is needless to state that if the sixth respondent appointment is a first division clerk in another institution managed by the third respondent Sangha is approved and admitting to grant in aid in the absence of acceptable explanation as to how he was appointed by the said Sangha as a lecturer, a political science in the fifth respondent college. Action is in accordance with law themselves be taken, including the criminal prosecution and criminality is found. Then my lord, the
No, but what is
appeal
your-
was filed.
No, but he is appointed as a lecturer in political science.
Political.
What is your locus standi?
Now, my lord, kindly see the annexure E. After tribunal passed the order. Tribunal passed the order. It is after it petition, annexure E.
Yes.
In that, my lord, page number 36. Column number 5, 36, that is a column of Damodar N. ರಾಜ್ಯಶಾಸ್ತ್ರ ಉಪನ್ಯಾಸಕರು 21/86 ವಿದ್ಯಾರ್ಥಿ MA ರಾಜ್ಯಶಾಸ್ತ್ರ ದೆನ್ ಸೇವೆಗೆ ಸೇರಿದ ದಿನಾಂಕ 16/6/95 ಈಸ್ ಎ ಫಸ್ಟ್ ಡಿವಿಷನ್ ಕ್ಲರ್ಕ್ ಇನ್ ಸಮ್ ಅದರ್ sister concern.
Page
36 of the appellate tribunal order. 36 ink place 36.
37.
ಇದರಲ್ಲಿ 36 ಅಂತ 36 ಅಲ್ವಾ? That is the column number 5 ಮೇಲೆ.
Column number
5. ಶ್ರೀ ದಾಮೋದರ ಎನ್ ರಾಜ್ಯ ಶಾಸ್ತ್ರ ಉಪನ್ಯಾಸಕರು 2/11/90 ಜನ್ಮ ದಿನಾಂಕ, ವಿದ್ಯಾರ್ಹತೆ MA ರಾಜ್ಯಶಾಸ್ತ್ರ, ದೆನ್ ಸೇವೆಗೆ ಸೇರಿದ ದಿನಾಂಕ 16/6/90 ಸಾಮಾನ್ಯ ಅಭ್ಯರ್ಥಿ. As on the date, he is a clerk, first division clerk, appointed in the another institution. Your lordship may kindly see regarding that aspect, I have produced the appointment letter at page number 25. Page number 25, ma'am. You are appointed as a FTC (25). You are appointed as a FDC at KVG Industrial Training Institute, Sulya, permanent basis. Your services in all respect will be governed by rules and regulations of our management of the institute and the directors of the employment and training Bangalore, Karnataka, which are in force, may be framed from the time to time. Now, he appointed as a first division clerk.
And subsequently in 2009, he applied for the lecture post. My lord, the
Applied for lecturer in 2000.
2009. Your lordship may kindly see the appellate authority after remand. Appellate authority after remand, my lord, conducted the recording of evidence, all the parties, and passed an order. In order, we can get it, my lord, in page number. Page number 47.
Now this revision appeal resulted in what happened in the revision appeal?
Resulted in, your lordship kindly last paragraph, I will read order of the last paragraph. Adesha 49. ದಾಮೋದರನ ರಾಜ್ಯ ಸಹ ಉಪನಾಯಕರು ಇವರ ವಿರುದ್ಧ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆ ಹೂಡಲು ಪದವಿ ಶಿಕ್ಷಣ ಪೂರ್ವ ಕೂಡಲೇ ಕ್ರಮ ಕೈಗೊಳ್ಳುವುದು. ದಾಮೋದರನು ರಾಜ್ಯ ಸಹ ಹುದ್ದೆಗೆ ಅನುದಾನಗೊಳಪಡಿಸಿದ ಆದೇಶವನ್ನು ರದ್ದುಗೊಳಿಸುವ ಬಗ್ಗೆ ನಿರ್ದೇಶಕರು ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣ ನಿಯಮಗಳ ಪ್ರಕಾರ ಕ್ರಮ ವಹಿಸುವುದು. This is the finding. Kindly note, this is the finding.
Now this is on what ground this order?
Ground 2. Your lordship may kindly see. ಈ ಪ್ರಕರಣದಲ್ಲಿ in page number 46, in page 46, paragraph ಈ ಪ್ರಕರಣದಲ್ಲಿ ಪರಿಶೀಲ ಸಭೆಯ ಕೆಳಕಂಡ ಅಂಶಗಳು ದಾಮೋದರ್ ಎನ್ ರಾಜ್ಯಶಾಸ್ತ್ರ ಉಪನ್ಯಾಸಕರು ಇವರು ಶ್ರೀ ಶಾರದಾ ಮಹಿಳಾ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಸುಳ್ಯ ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲೆ. ಈ ಕಾಲೇಜಿನಲ್ಲಿ ಅನುದಾನಕ್ಕೊಳಪಡಿಸುವ ಮೊದಲು ಶ್ರೀ ಕುರುಂಜಿ ವೆಂಕಟರಮಣ ಕೈಗಾರಿಕಾ ಸಂಸ್ಥೆ ಕುರುಂಜಿ ಸುಳ್ಯ ಈ ಪ್ರಥಮ ಸಹಾಯಕರಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದರೆ ಇಲ್ಲವೇ? ದಿಸ್ ಇಸ್ ದ ಫಸ್ಟ್ ಇಶ್ಯೂ. ಸೆಕೆಂಡ್ ಇಶ್ಯೂ, ಅರ್ಜಿದಾರ ಕೋರಿರುವುದು ಶ್ರೀಮತಿ ಕೆ ಭಾರತ್ ಶ್ರೀ ದಾಮೋದರ ಹುದ್ದೆಯಲ್ಲಿ ಅನುದಾನಗೊಳಿಸಲು ಬರುತ್ತದೆಯೇ? ಲಾರ್ಡ್ಶಿಪ್ ಮೇಲೆ ಕಳಿಸಿ ಫೈಂಡಿಂಗ್ ಫಾರ್ 1. ಸದರಿ 2 ಅಂಶಗಳು ಉತ್ತರ ಕೆಳಕಂಡಂತಿದೆ. ದಿನಾಂಕ 8/12/2015 ನಡೆದ ವಿಚಾರಣೆ ಸಮಯದಲ್ಲಿ ಪ್ರಾಚಾರ್ಯರು KV ಕೈಗಾರಿಕಾ ತರಬೇತಿ ಸಂಸ್ಥೆ ಸುಳ್ಯ ಇವರ ಪರವಾಗಿ ಶ್ರೀ ದಿನೇಶ್ MP ತರಬೇತಿ ಅಧಿಕಾರಿ ಇವರು ವಿರುದ್ಧ ಹಾಜರಾಗಿ ಶ್ರೀ ದಾಮೋದರನ್ ಪ್ರಥಮ ಸಹಾಯಕರಾಗಿ ದಿನಾಂಕ 18/10/97 ನೇಮಕಾತಿ ಆದೇಶವನ್ನು ನೀಡಲಾಗಿದೆ. ಅದರಂತೆ ಸದರಿಯವರು ಕೈಗಾರಿಕಾ ತರಬೇತಿ ಸಂಸ್ಥೆಯಲ್ಲಿ ದಿನಾಂಕ 20/10/97 ವರದಿ ಮಾಡಿಕೊಂಡಿರುವುದಾಗಿ ಶ್ರೀ ದಾಮೋದರ ಎನ್ ಇವರು ದಿನಾಂಕ 15/1/2001 ಸದರಿ ಹುದ್ದೆಗೆ ರಾಜೀನಾಮೆ ಸಲ್ಲಿಸಿದ್ದರಿಂದ ಅದನ್ನು ಅಂಗೀಕರಿಸಿ ತರಬೇತಿ ಸಂಸ್ಥೆ ಪತ್ರ ದಿನಾಂಕ 5/2/2009 ಸದರಿ ದಿನಾಂಕ 16/1/2000 ಅನ್ವಯಿಸುವಂತೆ ಕರ್ತವ್ಯದಿಂದ ಬಿಡುಗಡೆಗೊಳಿಸಲಾಗಿ ವಿಚಾರಣೆ ಸಮಯದಲ್ಲಿ ತಿಳಿಸುತ್ತಾರೆ ಹಾಗೂ ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಮೂಲ ದಾಖಲೆಯನ್ನು ಪ್ರಸ್ತಾಪಪಡಿಸಿರುತ್ತಾರೆ. ಪ್ರತಿವಾದಿ 2ರ ಪರವಾಗಿ ದಿನಾಂಕ 24/2/2014 ನಡೆದ ವಿಚಾರಣೆ ವೇಳೆಯಲ್ಲಿ ವಕೀಲರಾದ ಶ್ರೀ MS ಪ್ರಕಾಶ್ ಇವರು ಹಾಜರಾಗಿ ದಕ್ಷಿಣ ಕನ್ನಡ ವಿದ್ಯಾಸಂಘ ಸುಳ್ಯ ಇವರ ಆಧೀನದಲ್ಲಿ ಶಾರದಾ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಸುಳ್ಯ ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲೆ. ಈ ಕಾಲೇಜು ದಿನಾಂಕ 17/7/91 ಪ್ರಾರಂಭವಾಗಿರುತ್ತದೆ. KVG ಸಂಸ್ಥೆ ಮತ್ತು ಶಾರದಾ ವಿದ್ಯಾಸಂಸ್ಥೆ 2 ಆಡಳಿತ ಮಂಡಳಿಗೆ 19 ವರ್ಷ ಕಾಲ ಒಬ್ಬರೇ ಅಧ್ಯಕ್ಷರಾಗಿರುತ್ತಾರೆ. ಅಧ್ಯಕ್ಷರು ಸೂಚಿಸಿದ ಮೇಲೆ ಶ್ರೀ ಕೆ ದಾಮೋದರ್ ಅವರು 2 ಸಂಸ್ಥೆಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸಿರುವುದಾಗಿ ತಿಳಿಸುತ್ತಾರೆ. ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸಂಸ್ಥೆಯ ಅಧ್ಯಕ್ಷರು ಬರವಣಿಗೆ ಮುಖಾಂತರ ಸೂಚನೆ ನೀಡಿರುತ್ತಾರೆಯೇ ಅಥವಾ ಇಲ್ಲವೇ ಎಂಬ ಮಾಹಿತಿ ನೀಡುವುದಾಗಿ ಕೋರಲಾಗಿ ಸರದಿ ಮಾಹಿತಿಯನ್ನು ಬರವಣಿಗೆ ಮುಖಾಂತರ ನೀಡಿರುವುದಿಲ್ಲ. ಪ್ರತಿವಾದಿ 5ರ ಪರವಾಗಿ ವಕೀಲರಾದ ಶ್ರೀ ಓಂ ಶಿವರಾಮ್ ಭಟ್ ಇವರಿಗೆ ಹಾಜರಾಗಿ KVG ಸಂಸ್ಥೆ ಮತ್ತು ಶಾರದಾ ವಿದ್ಯಾಸಂಸ್ಥೆ 2 ಆಡಳಿತ ಮಂಡಳಿ ಅಧ್ಯಕ್ಷರು ಒಬ್ಬರೇ ಆಗಿರುತ್ತಾರೆ. ಆದರೆ ಕಾಲೇಜು ಬೇರೆ ಬೇರೆ ಆಗಿರುತ್ತದೆ. ಶ್ರೀ ದಾಮೋದರ್ ಇವರು KVG ಕೈಗಾರಿಕಾ ಸಂಸ್ಥೆ ಇಲ್ಲಿ ಪ್ರಥಮ ದರ್ಜೆ ಸಹಾಯಕರಾಗಿ ದಿನಾಂಕ 18/10/97 ಕಾರ್ಯನಿರ್ವಹಿಸಿದ್ದು ನಂತರ ಸದರಿ ಹುದ್ದೆಗೆ ರಾಜೀನಾಮೆ ನೀಡಿ ಶಾರದಾ ಕಾಲೇಜಿಗೆ ರಾಜಶಾಸ್ತ್ರ ಉಪನ್ಯಾಸಕರಾಗಿ ಚಮಾಟೆಗೊಂಡಿರುವಂತೆ ಈ ರೀತಿ ಸಮಂಜಸಲಾಗೂ ಒಪ್ಪದಂತಹ ಅಂಶಗಳು ಇಲ್ಲ. ಇವರು 2 ಸಂಸ್ಥೆಗಳಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸಿರುವುದು ವಿಚಾರಣೆಯಿಂದ ದೃಢಪಡಿಸುತ್ತೆ.
ಮಾನ ಮುಖ್ಯಾಲಯದ ರಿಟ್ ಸಂಖ್ಯೆ ನಂಬರ್ ಆದೇಶ ಪ್ರಕಾರ it is needless to say etc. what ordinally ಇದೆಯೋ ಅದು. Then ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣಾಧಿಕ ಸರ್ಕಾರಕ್ಕೆ ಶ್ರೀ ದಾಮೋದರ್ ಇವರನ್ನು ಅನುದಾನಕ್ಕೊಳಪಡಿಸುವ ಬಗ್ಗೆ ಪ್ರಸ್ತಾವನೆ ಕಳಿಸಿದಾಗ ಎರಡು ಸಂಸ್ಥೆಗಳಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಬಗ್ಗೆ ಎಲ್ಲೂ ಕೂಡ ವರದಿ ಮಾಡಿರುವುದಿಲ್ಲ. ಆದರೆ ವಿಚಾರಣೆಯ ವೇಳೆಯಲ್ಲಿ ಇಲಾಖೆಯವರಿಗೆ ಎರಡು ಸಂಸ್ಥೆಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವುದು ಇವರ ವಿರುದ್ಧ ಕ್ರಮ ಕೈಗೊಳ್ಳುವುದು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಅನುದಾನಕ್ಕೊಳಪಡಿಸುವಲ್ಲಿ ಈ ಅಂಶವನ್ನು ಇಲಾಖೆಗೆ ತಿಳಿಸಿದಲ್ಲಿ ಅನುದಾನಕ್ಕೊಳಪಡಿಸುವ ಪ್ರಶ್ನೆಯೇ ಉದ್ಭವಿಸುತ್ತಿರಲಿಲ್ಲ. ಇಲಾಖೆಯವರು ಸಹ ಸರಿಯಾದ ಮಾಹಿತಿ ನೀಡದೇ ಇರುವುದರಿಂದ ವಿಚಾರಣೆಯನ್ನು ತಿಳಿದು ಬರುತ್ತೆ. ಅದರಂತೆ ಶ್ರೀ ದಾಮೋದರ್ ಎಸ್ ವಿರುದ್ಧ ಕ್ರಿಮಿನಲ್ ಹೂಡಲು ಕ್ರಮ ಕೈಗೊಳ್ಳಬೇಕು. ಇವರನ್ನು ಅನುದಾನಿತ ರೈತ ಅನುಮೋದಿಸಿರುವುದನ್ನು ರದ್ದುಪಡಿಸಬೇಕೆಂದು ಕೇಳಿಕೊಳ್ಳಿ. This is the appellate authority finding, tribunal finding. Then, my lord, I will take to annexure A, which is the what fault the principal secretary had done while considering the revision petition.
No,
Lordship,
point number 2.
annexure A, my.
No, in the same order, the
Point.
finding on point number 2.
Point number 2 is whether other note. ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಅಡಿ TP 2000 ಶಾರದಾ ಪದವಿ ಕಾಲೇಜಿನ 4 ಉಪನ್ಯಾಸಕರು ಮತ್ತು 4 ಬೋಧಕೇತರ ಸಿಬ್ಬಂದಿಯನ್ನು ಅನುದಾನಕ್ಕೊಳಪಡಿಸಲಾಗಿದೆ. ಸದರಿ ಆದೇಶ ಶ್ರೀ ದಾಮೋದರ್ ಎನ್ ರಾಜ್ಯಶಾಸ್ತ್ರ ಉಪನ್ಯಾಸಕರ ಉದ್ದೇಶ ಒಳಗೊಂಡಿರುತ್ತದೆ. ಈ ಆದೇಶ ಹೊರಡಿಸುವ ಪೂರ್ವದಲ್ಲಿ ಶ್ರೀ ದಾಮೋದರ್ ಇವರು ಕೂಡ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದಾಗ ಎಲ್ಲಿಯೂ ಮಾಹಿತಿ ಸಲ್ಲಿಸಲು ಹಾಗೂ ಸದರಿಯ ಪ್ರಶ್ನಿಸಿ ಸಂಬಂಧಪಟ್ಟಲ್ಲಿ ದಾವೆ ಹೂಡಿದೆ. ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ 25 TPU 2010 ಅಲ್ಲಿ ಸದರಿ ಕಾಲೇಜಿನ ಇಂಗ್ಲಿಷ್ ಉಪನ್ಯಾಸ ಶ್ರೀ ಗಣೇಶರಾವ್ ಶ್ರೀ ಬಾಲಕೃಷ್ಣ ನಾಯ್ಕ್ ಇವರ ನೇಮಕಾತಿಯನ್ನು ಆದೇಶ ಹೊರಡಿಸಿದ ದಿನಾಂಕದಿಂದ ಸಹಾಯಕ್ಕೊಳಪಡಿಸಿ ಆದೇಶಿಸಿದೆ. ಆದ್ದರಿಂದ ಸದರಿ ಸಮಸ್ತ ಉಪನ್ಯಾಸರ ಹುದ್ದೆ ಖಾಲಿ ಇರುವುದಿಲ್ಲ. ಸದರಿಯವರು ಕಾರ್ಯನಿರ್ವಹಿಸಲು ಪ್ರಶ್ನೆ ಶ್ರೀಮತಿ ಭಾರತೀಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಶ್ನೆ ಶ್ರೀಮತಿ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕಳಿಸಿ ದಿಸ್ ಪಾರ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. The appointment as a political science in 2009. Your Lordship may kindly see, as on that, since the SC/ST candidate are not available, that is vacant for 2 years. The appointment took on 29/12/2011. At that relevant period, my lord, it is a vacant post.
No, but now in so far as your position is concerned, they have rejected it, isn't it?
Then rejected.
Then did you challenge that?
We have filed the writ petition here. Earlier writ petition, what I have read, that writ petition filed.
Against this order?
Against this order. Not this order. The appellate revisional authority.
You have filed a memo, is it?
Filed the memo, not file, it is the original paper book one.
Original paper book stops at 60.
60. Not, it is, my lord, in 50, 54, 50, 60, 61, your lordship may kindly see 61. Not 61. 61.
Some
What
page-
the
There's some page mistake.
Vicharana notice?
Huh?
Vicharana notice.
58.
Vicharana notice. Your lordship may kindly see. The ಕರ್ನಾಟಕ ಕಾಯ್ದೆ ಸರ್ಕಾರಕ್ಕೆ ಪರಿಹರಿಸನ ಅರ್ಜಿ ಇದರ ವಿಚಾರಣೆ ದಿನಾಂಕ 1/3/28 ಬೆಳಿಗ್ಗೆ 12 ಗಂಟೆಗೆ ನಿಗದಿಪಡಿಸುವ ಮುಂದೂಡಿ ದಿನಾಂಕ 3/3/2018 ಬೆಳಿಗ್ಗೆ 11:30 ಗಂಟೆಗೆ ಮೇಲ್ಕಂಡ ಪ್ರಾಧಿಕಾರ ಕಚೇರಿಯಲ್ಲಿ ನಡೆಸಲು ನಿರ್ಧರಿಸಲಾಗಿದೆ. This notice, my lord, reached after the hearing date. That I have produced the poster in the page earlier to that, my lord, page 60. Earlier to this one. This is the postal.
On what date?
It is received 8/3/2018. Without hearing me, without giving you opportunity, my lord, I have brought to the notice of the court this aspect.
Correct, but you have not, challenged this order of the revisional authority.
Which
This order of the revisional authority, you have not challenged.
I have challenged in this writ petition.
Before.
This writ petition before this honorable court in this writ petition.
36864.
No, yes.
No.
No, 18/560. This writ petition I have challenged that order.
Now.
Annexure A, impugned order.
Yes.
The impugned order passed without following the principles of natural justice. I have received the notice subsequent to that. I have written the letter, and also your lordship may kindly see page 50. 50, I have submitted a letter to the revisional authority and intimated. It is in handwriting. This is the mail.
No,
typed copy is the next to this thing. Typed copy also I produced.
On facts, my lord, sir.
And my lord, this was served on my lord with the personally, and statement of objection also filed.
But this order, which you have challenged,
is clearly states that my lord not present. So and so not present. It is in the order. Last paragraph, my lord. I will take your lordship to the page 21, para 7 of the order.
No, just 1 minute. Now this order against Damodar was challenged by him.
Challenged by Damodar. I am the.
Now what happened to that order?
That order I have challenged in this writ petition.
No, that the order at Annexure E was challenged independently by.
Annexure A order.
Annexure A order.
Annexure A order operative portion is at page 22.
So E was challenged at A.
At annexure.
Yes. And then what happened in this?
Principal Secretary set aside the order passed by the revisional authority.
Then the
revision appeal. And my lords allowed the revision petition filed by me. Kindly see the operative portion of the order which is available at page 22.
Now my argument, my lord, I agreed by 2 grounds I am urging. One ground is not met the principles of natural justice. I have produced the postal authority and all these things. According to them, 1/3 is fixed and 3/3 was postponed. I am residing in South Canara, Dakshina Kannada. The post also done on 3/3. It shows that post also done 3/3. And hearing date taken on 3/3. And my lord, in the paragraph 7 of the order, impugned order at page 21, case called out on 3/3/2018. The petitioner, respondent number 3 and 5 are present. Respondent number 6 was absent.
So you're reading at?
Reading at para 7.
Page?
Page 21.
Now this para 7 is the proceedings in the revision petition.
Revision petition.
There also you were not.
Oh,
present.
not served the notice. It is served after hearing date. That is why I am showing the their notice and also postal this thing. Your lordship, case called out on 3/3/28. The petition respondent number 1, 2, 3 and 5 present. Respondent 6 was absent. Respondent 6 is the petitioner hearing. And connected to that, I have shown the postal acknowledgement, all these things. The same was served after 4 days of the hearing. Usually 1/3 was the date of hearing. That was changed to 3/3. And on the same day, 3/3, they have posted the notice. And it reached on 8/3/2000 after hearing date over. So principles of natural justice, no opportunity is given to the petitioner to contest the matter.
No, the first order was at annexure E.
Annexure.
That order at annexure E, you have challenged in the present proceedings.
No. Annexure E was challenged by the challenged by the Damodar in the revision review petition, and that resulted in the order in annexure A.
No, at annexure E, your claim was rejected.
Yes.
Where have you challenged that?
No. We have not challenged.
Then? At annexure E, there were 2 points of consideration framed. One regarding Damodar, against which an adverse order is passed. 2, whether you are entitled to that post. That claim was rejected. That you have not challenged.
Your lordship may kindly see. Regarding that aspect, I am telling my lord, since the revision petition, they have not served the notice. I have not in opportunity filing a counterclaim. When they have not this thing counterclaim, I have to make my objection statement. That was not given the opportunity to me, because the hearing date is first hearing date itself is the order passed, and the notice received after 5 days.
Annexure E order was passed on 28/11.
28/11. Against that, they have filed the revision. In the revision, hearing date fixed as per the document number 61. 61 notice issued, my first notice.
No, but then you said in annexure E, you were not notified.
Annexure E notified. Annexure E notified. After filing the.
No, correct. I'm only on the point. Annexure E, you suffered an adverse order. Against annexure E, proceedings were initiated only by Damodar. You have not challenged.
Not
then?
My lord, the contention, while in the revision petition itself, is the counterclaim has to be.
No, you should independently challenge.
Then, my lord, my one ground is principles of natural justice not followed. Then another thing, my lord.
No, in the annexure A proceedings, you are not a necessary party at all. Your claim has been rejected, you have not challenged.
Opportunity ಕೊಟ್ಟಿಲ್ಲ ಅಂತ Revisional.
No, why should they give you? You have
Yes,
lost.
there is a decision from this honorable court stating that, my lord, how to give a conduct a.
Your plea, let me
Decision. That note B, my lord, it starts from paragraph 12. So code is 4131 Karnataka Education Act, section 130, education institutional appeal, revision and review rules review order passed by the appellate authority and review authority must assign reasons for finding recorded. Authority has to apply its mind towards the facts of the case while passing the order passed without considering the ground of appeal and written statement filed by the parties in violation of the procedure contemplated in CPC 19 Rule 1998. Paragraph 12 onwards, it will be start my paragraph 12 of the order. This particular procedure is not in detail contemplated under the Karnataka Education Act or rules noted above. Therefore, whenever the appeal is filed or the revision is filed or review is called on, the authorities have to bear in their mind as to how the appellate authority has to consider the appeals. If the above said provisions is applied, if both the parties are contesting, the appellate authority has to consider what exactly the points involved in that particular case. Here, no point is made out. No point is, there are 2 points made by the tribunal. Here, no point is made out in the annexure A order. Or consisting authority has to consider exactly the points involved in the particular case. Here, no point is made out. And it should frame the points for determination. It is not frame determination. And it should give its findings on those points for determination, and it should give its findings on these points for determination. That is the decision thereon. In between, too, the authorities have to consider the material on record, the allegations made in the pleadings of the parties and the evidence made by them, if any other submissions made by the councils, and based upon the appreciation of the above said aspects, the authorities have to arrive the conclusive by reasons as to why they arrive such conclusion. Therefore, all the basic principles of civil jurisprudence be followed whenever a dispute arises between the parties to considered either by judicial authorities or by the quasi-judicial. The decision should be always based on the material available on record. Here, no record was called. Trial court appellate record was not on record. The findings without any reason is no use because of the appellate authority, reviewing authority, or the upper courts would not be in a position to understand as to whether the appellate court, review court, or revisional court have in fact understood the case of the parties and what exactly the points which is involved in the particular case and how the decision has to be taken. Therefore, the procedure inevitable almost all the cases wherein the authorities are bound to follow the principles of natural justice. Here, notice given after received by the after conducting the proceeding. Now, let me back to the orders which is involved in this particular case, appeal so and so, etc. By the Principal Secretary, Health and Family Welfare Department, 15/3/2000, which order in Kannada language already extracted above. In this particular order, the appellate authority has written order that 3 paragraphs. Out of them, one of the operative portions of the order. In here, 2 paragraphs, it is only stated that appeals have been filed by the respective parties and the advocate are present by the have argued before the appellate authority and also submitted.
Now let us have a look at the order at annexure A.
Annexure.
Now this is not a suo motu revision. It's a revision at his instance, isn't it?
Yes.
Now let us have a look at that order.
Para 6 views. Page 21.
In this order, two issues are framed. The revisional authority considered only one issue. Annexure A, my lord. Annexure A. Last by annexure A, Your Lordship may kindly see the page 2, facts, mention the facts. Para 6, up to para 6, what is the case of the petitioner, what is the case of the respondent? Then, my lord, the petitioner present that appointment or so grant in aid granted him on heard the arguments of respondent so and so, grant in aid for NS Damodar NS not working is another institution as he had resigned on 15. In fact, 15/1/2000 government issued orders granting giving 4 out of 6 to them were to be circulated SCST. It is a fact that Bharati is the respondent number 6 junior demand. Since Bharati, there is no complaining claim Balakrishna, hence he is exempted from proceedings. Since there is no contention between Damodar and the only recent order of the respondent stating that Damodar was working as a two places in found. Hence, in view of the above, revision petition 132 Karnataka so allowed and past respond to review appeal is set aside. That's all. No record was called, no evidence, everything is not considered.
Yes,
So
what-
they are only reproducing the both the cases and only one para, 2 para or past the order.
Let us, yes, what do you say?
Let's on facts.
No
my lords.
reasoning at all.
On facts, my lords, 16/1/2009 was the date of appointment, my lords, of the present private respondent to grant in aid. Insofar as, my lords, political science subject is concerned, not, my lords, sociology. my lords. Now, kindly see, my lords, the recommendation was made by the management in respect of the petitioner as well as, my lords, the private respondent. Both were recommended. Now, my lords, kindly see page 21, my lords, reasons assigned by, my lords, the principal secretary. Para 6. The petitioner further contended that the management has not committed any discrimination in the matter. It is the case of the petitioner that the names of 6th respondent as well as the petitioner herein were recommended for grant in aid. However, the proposal of the 6th respondent was rejected at the selection level, contending that the management has to follow the roster system while obtaining an order for grant in aid. Subsequently, the government has directed to appoint the SC and ST lecturer for the post of English and Sociology in the said college. And as such, the proposal of the 6th respondent herein was dropped by the government itself and not by the management. Lords, I'll pause here for a moment, my lords. 6th respondent is the petitioner before my lords now. It is to be noted that since the proposal of 6th respondent herein was rejected, as per the reservation policy, one Balakrishna Naika was appointed for sociology and one Ganesh was appointed as English lecturer. Therefore, the
sixth respondent was a applicant. for-
sociology post.
Yes.
Therefore, the 6th respondent should have stake or no grievance in the matter. In addition to that, 6th respondent is a sociology lecturer and the petitioner herein is a political science lecturer. In spite of appointment of Balakrishna Naik to the post of sociology lecturer, the respondent number 6 has not challenged the said appointment. Case was called out so and so. Balakrishna Naika, sociology lecturer, was present and informed that he was appointed on 1/8/2009 and grant in aid was granted to him on 29/12/2011. Heard the arguments, the respondent number 1 clarified that as on the date of grant in aid, Damodar N was not working in another institution as he had resigned on 15/1/2009. In fact, on 15/1/2009, the government issued order of grant in aid, giving 4 out of 6 posts. 2 of them were to be recruited from SC/ST. It is a fact that Bharati, the respondent number 6, is junior to Damodar. Since Bharati is non-SC/ST, there is no competing claim with Balakrishna Naik. Hence, he is exempted from the proceedings. Since there is no contention between Damodar and management, only reason for the order of the respondent number 1 stating that the Damodar 1 was working in 2 places is found baseless. Hence, the order passed by the Revisional Appellate Authority as per Annexure E was set aside. Now, may I request my lords to kindly turn to page 46 minutes. In fact, 48 minutes. The answer to the claim made by the petitioner passed by, my lords, the Revisional Appellate Authority. ಸರ್ಕಾರದ ಎರಡನೇ ಅಂಶಕ್ಕೆ ಉತ್ತರ, my lords. Para 3, page 48. ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಇಡಿ ಸೋಂಡ್ಸೋರ್ ಶ್ರೀ ಶಾರದಾ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜಿನ 4 ಉಪನ್ಯಾಸಕರು ಮತ್ತು 1 ಬೋಧಕೇತರ ಸಿಬ್ಬಂದಿಯನ್ನು ಅನುದಾನಕ್ಕೊಳಪಡಿಸಲಾಗಿದೆ. ಸದರಿ ಆದೇಶದಲ್ಲಿ ದಾಮೋದರ ಎನ್ ರಾಜ್ಯಶಾಸ್ತ್ರ ಉಪನ್ಯಾಸಕರ ಹುದ್ದೆಯೂ ಸಹ ಒಳಗೊಂಡಿರುತ್ತದೆ. ಈ ಆದೇಶ ಹೊರಡಿಸುವ ಪೂರ್ವದಲ್ಲಿ ದಾಮೋದರ್ ಅವರು 2 ಕಡೆ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವುದಾಗಿ ಅರ್ಜಿದಾರರು ಎಲ್ಲಿಯೂ ಮಾಹಿತಿ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ದಟ್ ಈಸ್ ದಿ ಪಿಟಿಷನರ್, ಮೈ ಲಾರ್ಡ್ಸ್. ಹಾಗೂ ಸದರಿ ಆದೇಶವನ್ನು ಪ್ರಶ್ನಿಸಿ ಸಂಬಂಧಪಟ್ಟ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾವೆ ಹೂಡಿರುವುದಿಲ್ಲ. ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋಂಡ್ಸೋರಲ್ಲಿ ಸದರಿ ಕಾಲೇಜಿನ ಇಂಗ್ಲಿಷ್ ಉಪನ್ಯಾಸಕರಾದ ಶ್ರೀ ಆರ್ ಗಣೇಶ್, ಸಮಾಜಶಾಸ್ತ್ರ ಉಪನ್ಯಾಸಕರಾದ ಬಾಲಕೃಷ್ಣ ನಾಯ್ಕ್ ಇವರ ನೇಮಕಾತಿಯನ್ನು ಆದೇಶ ಹೊರಡಿಸಿದ ದಿನಾಂಕದಿಂದ ಸಹಾಯಾನುದಾನಕ್ಕೆ ಒಳಪಡಿಸಿ ಆದೇಶಿಸಿದೆ. ಆದ್ದರಿಂದ ಸದರಿ ಕಾಲೇಜಿನಲ್ಲಿ ಸಮಾಜಶಾಸ್ತ್ರ ಉಪನ್ಯಾಸಕರ ಹುದ್ದೆ ಖಾಲಿ ಇರುವುದಿಲ್ಲ. ಸದರಿ ಅವರು ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದಾರೆ. ಸದರಿ ಆದೇಶವನ್ನು ಪ್ರಶ್ನಿಸಿ ಅರ್ಜಿದಾರರಾದ ಶ್ರೀಮತಿ ಭಾರತಿ ಇವರು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಶ್ನಿಸಿರುವುದಿಲ್ಲ. ಶ್ರೀ ಭಾರತಿ ಕೆ ಸಮಾಜಶಾಸ್ತ್ರ ಉಪನ್ಯಾಸಕರು, ಶ್ರೀ ಶಾರದಾ ಮಹಿಳಾ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು, ಸುಳ್ಯ, ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲೆ ಇವರು ಆಡಳಿತ ಮಂಡಳಿ ಅಧ್ಯಕ್ಷರು ತಮ್ಮ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋಂಸೋರಂದು ನೇಮಕಾತಿ ಆದೇಶ ನೀಡಿದ್ದು, ಸದರಿ ಆದೇಶದಂತೆ ಶ್ರೀ ಭಾರತಿ ಕೆ ಇವರನ್ನು ಕಾಯಂ/ಪೂರ್ಣಕಾಲಿಕ ಅಥವಾ ತಾತ್ಕಾಲಿಕವಾಗಿ ನೇಮಕ ಮಾಡಿದ್ದಾರೆ ಎನ್ನುವ ಬಗ್ಗೆ ನಮೂದಿಸಿಲ್ಲ. ಉಪನಿರ್ದೇಶಕರು ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣ ಇಲಾಖೆ ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲೆ ಇವರ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋಂಸೋರಂತೆ ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ವರದಿ ಅನ್ವಯ ಶ್ರೀಮತಿ ಭಾರತಿ ಇವರು ಆಡಳಿತ ಮಂಡಳಿ ನೇಮಕಾತಿ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋಂಸೋರ ಪ್ರಕಾರ ಸದರಿ ಕಾಲೇಜಿನಲ್ಲಿ ಸಮಾಜಶಾಸ್ತ್ರ ಉಪನ್ಯಾಸಕರಾಗಿ ದಿನಾಂಕ ಸೋಂಸೋರಿಂದ ಸೋಂಸೋರವರೆಗೆ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿರುತ್ತಾರೆ. ನಂತರದ ಅವಧಿಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸಿರುವುದಿಲ್ಲ.
Only till 2009.
2009. ಅರ್ಜಿದಾರರ ಮತ್ತು ಪ್ರತಿವಾದಿಗಳ ವಾದ ವಿವಾದಗಳ ಮೂಲಕ ಸೋಂಸೋ. Issue number 2 was answered in negative. That has attained finality. She has not challenged that. Lords, insofar as answering issue number 1 in the affirmative, my lords, I preferred revision before the authority, revisional authority. That order came to be set aside.
What do you say about this judgment?
Please, now insofar as that particular judgment is concerned, my lords, when she has not preferred any appeal, challenging the, my lords, finding recorded against her. Now, my lords, as rightly observed by my lords, that it is a dispute between myself and my lords government. And the management has, my lords, specifically stated, my lords, Balakrishna Naik has been appointed pursuant to the grant in aid. My lords, in fact, my lords, the name was recommended by the management. The name of the petitioner was also recommended. My lords, that was rejected not by the management, my lords, by the state government on the ground that, my lords, you should follow the roster. And in the roster, my lords, it was reserved for, my lords, one English lecture post was reserved for the SC category. And, my lords, the sociology was reserved for, my lords, ST category.
So that Balakrishna and the other person are SC.
SC and ST.
To her
Ganesh and, my lord, that order is not challenged. Now, political science, she even, let us assume for this.
Under 132.
Yes.
What is the subject matter of the revision? Only the adverse finding?
Adverse find.
Or the entirety of the order?
My lord, so 132.
Entire order, my lord. 132.
The revision filed by me, my lords.
No,
No,
correct.
section.
Under 132.
Yes.
Act education.
130. 131, my lord. 131.
Now this annexure is under 132.
130, annexure A is the appeal filed under section 132.
130.
130.
130. 130 of the Karnataka Education Act.
My lords will get at page 19 itself. The petitioner filed the above revision petition number so and so under section 132 of Karnataka Education Act. First paragraph itself. My respectful submission is, my lords, once the finding recorded by the Revisional Appellate Authority has attained finality, she has no say in the matter. That too, my lords, after lapse of 15 years.
32 is the
No, the only,
review.
correct.
And 131, it is state government and also aggrieved party, both says, 131.
No, but this is filed under 132.
132,
This is filed
Yes,
under
yes.
132.
revision filed under 132.
Now what?
Then, my lord, the
Just one
state-
minute, just one minute.
I will read 131, my lord.
No, but
The state government,
no, but we are under 132 now.
132, review.
May I request,
Under 132.
may I request,
It
my
is a
lords, to
review,
kind.
review they have filed.
May I request my lords to kindly see my
You
statement?
before the same authority.
Sir, one nimsh, sir.
appeal letter.
Sir, one nimsh. Kindly take my statement of objections. Ma'am.
Hmm.
My statement of objections, annexure R1 for a moment. R1 page 12. Relevant page is page 13, ma'am. Page 13.
Yes.
Page 13, ma'am.
Huh.
Kindly see memorandum of revision petition filed under section 131.
131.
131. This was filed by me before the revisional authority.
So it is 131.
131.
Just read 131.
Yes. The state government may either suo moto or on an application by from the person, any person interested, call for and examine the record of the educational institution or any authority, officer or person in respect of any administrative or quasi-judicial decision or order, not being a proceedings in respect of which reference to an arbitrator or an appeal to the High Court is provided, to satisfy themselves as to the regularity, correctness, legality, or propriety of any decision or order passed therein. And if in any case it appears to the state government that any such decision or order should be modified, annulled, or reversed, or remitted for reconsideration, they may pass order accordingly, provided that the state government shall not pass any order adversely affecting any party unless such party has had an opportunity of making a representation. The state government may stay the execution of any such decision or other pending.
So you are saying that.
Notice not served on,
No,
on-
you are-
as on the date of hearing.
You are saying that you cannot enter into the other part which is not challenged.
Yes.
Under 130.
130.
Because it is the instance of a private party.
It is at the instance of private party and that has attained finality. Nobody has challenged it. And I am not aggrieved by that. I am aggrieved only by the direction issued so as to initiate criminal prosecution against.
According to your subject matter in 131.
131.
Only the adverse finding in that.
Finding recorded by.
If it was suo moto, then the entire.
Then it in its entirety, the
Could have been looked.
it could have been considered. This
Here
is
entirety
on an
not
application
considered, my
filed by
lord.
me.
Here entirely it is not considered. There are two findings, 1 and 2. Entirely not considered.
Not required.
No document record, trial court records are not called for. No evidence was gone through it and merely passed the order, hearing the argument, that's all. Whether that is not permissible under the decision of our honorable court and also under the said section.
Let us, yes, the petitioner, Bharati, has filed the present petition seeking for setting aside of the order passed by the first respondent, Principal Secretary, Government of Karnataka, Department of Education, in exercise of the revisional power, which order is produced at annexure A. By virtue of the order at annexure A, the revision filed under 131 of the Karnataka Education Act.
Yes.
Has been assailed. The revision filed under 131 of Karnataka Education Act by Damodara, the respondent number 6, by respondent number 3 was allowed, setting aside the order passed on 28/11/2017 in revision appeal 1110 of 2014. Full stop. By virtue of the order passed at annexure E, the revision appeal under number 110 of 2014 was filed by Bharati, the petitioner herein, assailing the action, assailing the order What was that annexure B in the writ petition?
Writ petition was upon, including my name in grant in aid, my lords.
Assailing the subject, the inclusion of the third respondent within the ambit of grant in aid in place of the claim of Bharati. Full stop. In fact, the petitioner had filed a writ petition 36864 of 2009, which came to be disposed of on 27/7/2012. Page
Page 30.
and the said writ petition came to be disposed of with the observations as made.
Page 32, my lords.
At para 2, which reads as follows, full stop. Consequent to such direction, the revision appeal was taken up on record, full stop. In the revision appeal, the facts that were laid out was that the third respondent Damodar was stated to have been working simultaneously in two institutions.
Two institutions. One
Name-
first division clerk and another.
Namely, as a first division clerk in
In Kulanji, Venkatramana Gowda.
where do you get that? Was working as a first division clerk in KVG Technical Training Institute,
Yes.
as well as was working as working in the group institution, namely Sharada
Pre-University College.
Sharada
Pre-University College.
Sharda Pre-University College as a political science lecturer. Full stop. It was contended that such dual work in two institutions was impermissible. Full stop. The further contention raised was that the petitioner herein was eligible and at the prejudice of the petitioner, the third respondent was working.
And one
In
submission.
the revision appeal,
One submission, roster system. Under roster system, she is eligible. In 2011 only that appointment made.
full
To
stop,
the
it was
vacant
further
post.
contended that the petitioner was eligible under the roster system. Full stop. 2 points for consideration were framed in the revision appeal proceedings. One, whether Sri Damodar, political science lecturer, was working in Sharada Women's Pre-University College
Modalu.
before the post was subjected to grant in aid.
May ulta.
Huh.
Whether he was working in KVG Technical Institution before he was applied for Sharda College.
Whether the third respondent Damodar was working in the KVG Technical Training Institute as a first division clerk prior to his appointment as political science lecturer in Sharada Women's Pre-University College,
Yes.
Sulia. Point number 2, whether Bharati petitioner herein could have been appointed to the grant in aid post now occupied by Damodar. Full stop. Insofar as point number 1 is concerned, the Revisional Appellate Authority had recorded a finding that the third respondent was working simultaneously in both the institution, and accordingly, the grantee aid with respect to the post to which he is appointed had to be cancelled, and proceedings were to be initiated on the criminal side against the third respondent. Full stop. Insofar as point number 2 is concerned, the authority has answered in the negative while observing that Ganesh was appointed as an English professor and Sri Balakrishna Nayak has been appointed as a professor of sociology since 29/12/2011 itself. And accordingly, there was no post vacant insofar as the claim of petitioner for the post of sociology. Full stop. It is further observed that the petitioner had not challenged the appointment of Ganesh or Sri Balakrishna Nayak. It must be noticed that as against such order, insofar as the adverse finding on point number 1, the third respondent had approached the Revisional Authority under section 131 before the Principal Secretary to Government. Full stop. It is at this point, it must be noticed that though the petitioner had not challenged finding on point number 2, it was the submission made by counsel for the petitioner that the petitioner was not aware of the date of hearing as order came to be passed on 28/11/2017. Now, date of hearing before this.
No. Order came to be passed on 12/3/2018. Your lordship will get at page 22.
That is in the fresh proceedings
Fresh
at annexure A. Last in, but no, has not challenged the finding at point number 2. Full stop. Next. Insofar as the revision proceedings under 113/2017, the same has culminated in an order being passed whereby the revision under 131 of the Karnataka Education Act, wrongly noticed as proceedings under 132 of the Karnataka Education Act in the impugned order at annexure A, came to be allowed. And finding at point number 1 in the proceedings in revision appeal 110 of 2014 came to be set aside. Full stop. The authority concerned has set aside the said finding while observing that there was no material to show that the third respondent was working in both the institutions simultaneously. Full stop. Insofar as the observation made at para 6 and 7 is concerned, it must be noticed that the reasoning of the impugned order is found in para 6 and 7, whereby the authority has observed that the petitioner's proposal of selection was rejected by the government itself, by the government.
Please.
The petitioner's the petitioner's selection was rejected by the government.
By the
itself,
government.
and not by the management. in light of the roster system. Full stop. It was further noticed that the government had directed to appoint SC and ST lecturers for subject in English and sociology, and accordingly, the proposal of the petitioner herein was dropped by the government. Full stop. It is further noticed that since proposal of the petitioner herein was rejected as per the reservation policy, and taking note that Balakrishna Naik was appointed for sociology and Ganesh was appointed as English lecturer, as regards which no challenge was made, and also on the ground that the appointment of Sri Damodar was as regards a political science lecturer, and the claim of the petitioner was as regards the post of
Political science.
petitioner, English,
So petitioner sociology.
sociology. The claim of the petitioner was rightly rejected by the authority. Full stop. It was further noticed that the finding of the third respondent that he was working in another institution could not be accepted, as he had resigned in the earlier institution on 15/1/2009 and was only subsequently appointed to the post which he was currently occupying. Such of the proceedings have been challenged in the present writ petition. Full stop. The claim of the counsel for the petitioner is that the revision petition 113 of 2017 was disposed of on 12th March 2018. And though the petitioner herein was arrayed as sixth respondent in the revision petition proceedings in revision petition 113 of 2017, notice itself was served on the petitioner herein on
8/3/2008.
on 8/3/2018, and accordingly, the order passed was in gross violation of principles of natural justice, as the petitioner herein did not have sufficient opportunity to put forth their case in the proceedings. Learned counsel for the petitioner, as regards the contention that the adverse finding in point number 2 made by the revision appellate authority in terms of the order at annexure E was not challenged, had submitted that if the petitioner herein was notified, necessary counterclaim would have been filed, and relies on order passed in People's Education Society and Trust Belgaum versus Secretary to Government of Karnataka and others in WP 68093 of 2011. Full stop. That apart, next para. It is submitted that a procedure requires to be followed by the authority while passing an order in appeal or revision, which would include framing points for consideration and follow the procedure as contemplated under CPC, which has not been challenged, which has not been followed. Full stop. Next. Learned counsel appearing for the respondent, on the other hand, would contend that in terms of the proceedings at annexure E, the finding at point number 2 not having been challenged, and the order at annexure E, insofar as the adverse finding at point number 1 was challenged by the third respondent before the revisional authority. Full stop. He submitted that accordingly, what was there before the revisional authority was only the challenge as to the finding on point number 1 and nothing more. And accordingly, the order passed by the revision authority could not be assailed. Full stop. Heard both sides. At the outset, it must be noticed that as narrated in the facts, before the proceedings at Annexure E, amongst the 2 points for consideration that were framed, point number 2 for consideration related to whether the petitioner could be, the claim of the petitioner could be considered as regards the post of grantee need. That issue was answered in the negative, and the same has not been challenged. Though counsel for the petitioner has contended that in the proceedings under 131, if he was notified, he could have raised a counterclaim. However, what must be noticed is that the revision filed under 131 was by the third respondent only on the adverse finding at point number 1. If that were to be so, the question of the revisional authority entering into the portion of order not relating to the petition, not relating to the third respondent, but the petitioner would not arise. Section 131 reads as follows. Next. It is clear from the scope of section 131 that the revision that is to be entertained by the state government is either suo motu or on an application from any interested person. Once such revision is entertained, needless to state, it's only that portion of the order at the instance of a person interested that could be taken note of by the state government in the revision. This would be in contradistinction to a suo motu revision to be entertained by the government, wherein the entirety of the order may still be open for reconsideration. If that were to be so, we find that the revisional authority has rightly passed the order which cannot be open to question. Insofar as the findings on merits also, it must be noticed that the revisional authority has clearly noticed at para 6 of the impugned order that the post for which the third respondent had applied and was working is one of political science, while the claim of the petitioner was as regards the post of sociology. It was further held that the post of English and sociology was already occupied by Balakrishna Nayak, a sociology lecturer, and the English subject lecturer's post was already selected by Ganesh, and such orders had not been challenged. Insofar as the finding as regards the third respondent is concerned, a clear finding is recorded that the working of Sri Damodar in the Sharada Pre-University College was only after he had resigned in the earlier institution on 15/1/2009. Accordingly, we find that there are no reasons to interfere with the order, and accordingly, the petition is rejected. One para. Insofar as the contention that the procedure as contemplated by the coordinate bench has not been followed, as was laid down in People's Education Society and Trust Belgaum case, it must be noticed that in the present case, substantially, though points for consideration have not been framed, the impugned order reflects to identification of the issue and the reasoning concerned. Further, we find that in light of absence of power of the revisional authority to consider the case of the petitioner cannot have any grievance to the order at Annexure A when the proceedings at Annexure A was limited only to the grievance of the third respondent and not as regards point number 2 held against the petitioner. Accordingly, petition is rejected.
Great.
T1.
Appearing for the petitioner. The petitioners they are appointed in a clear vacancy as a assistant teacher under the respondent number 1 educational institution, which is a
Who is the contesting respondent?
respondent number 1 min.
Then I'll pass over, but let me see. Respondent number 1 is the contesting respondent.
Respondent 1.
Yes.
May I appear for the first respondent council?
Respondent number 1.
Yes.
The petitioners were appointed as an assistant teacher in under the respondent number 1, my lord. The said appointment was made under rule 48 of the grant in aid rules read with Karnataka Education Act, my lord. I have extracted the said rule in my writ petition. Your lordship may kindly see page number 9 of my writ petition, my lord. The petitioner number 1, K.R. Vishwanath, appointed on 2/6/2018. They are appointed during the year 2006-2008. I have extracted in my writ petition in column page number 9, my lord. Typed copy, page number 9 of the writ petition. And accordingly, I have produced the annexure A in respect of the date of appointment on a consolidated amount of rupees 500 per month. Well, column number 3, consolidated salary per month, 500 per month. These petitioners were appointed under Rule 48 of the Grant in Aid Code, my lord.
That is for 6 months.
That is for 6 months. But however, there is no any order of termination. They have continued up to 2013. And more than 2013, my lord. Some were worked more than 14 years, 13 years, so and so on. The rule says for a period of only 6 months. That is a temporary course. My respectful submission before your lordship is that they are not, they have admitted their appointment, and accordingly, annexure A, your lordship may kindly, annexure B, my lord. They have issued an Tatkalika Nemakati Adesha, annexure B, typed copy, page number 34, my lord.
No, now, this is a aided institution.
Aided institution.
So the government, you have taken a
Government
stand?
also contacting part.
Huh? They are there.
Aided institution.
They have also filed their statement.
They also.
Objection is, the thing is there, consolidated salary, they are appointed. Now, my lord, as per the rules, my lord, as per the rules, they cannot be regularized. It is a aided institution. Invitation has to be called, reservation has to be followed. All those things are there.
I agree, my lord. They must follow the reservation and they follow the rules as per and under the recruitment rules of the appointment of the institution, my lord. Your lordship may kindly see, they have issued these admittedly these petitioners are worked more than 13 years, 14 years and more than 10 years for a consolidated amount of rupees 500 only. My respectful submission before your lordship is that they have issued an annexure B, Tatkalika Nemakati Adesha. In these annexure B, typed page 34, my lord. Issued the sum of the persons who are in the present each petition, sum of persons are not at all known. And they are called for interview. I interview kuda correct karlilla avaru. Now subsequently annexure D, your lordship may kindly see the circular issued by the Commissioner of Public Instructions, annexure D, my lord. Annexure D. Your lordship may kindly see Vishaya T.R. Subbanna Sarvajanika, that is respondent number 1, my lord. T.S. Subbanna Sarvajanika Shikkana Vidyaswami Vidyarana Mysore ಇವರ ವತಿಯಿಂದ ನಡೆಯುತ್ತಿರುವ ಆಧುನಿಕ ಪ್ರೌಢಶಾಲೆ ಖಾಲಿ ಇರುವ ಸಹಶಿಕ್ಷಕರು ದೈಹಿಕ ಶಿಕ್ಷಕರ ಗ್ರೇಡ್ ಹುದ್ದೆಗಳ ಭರ್ತಿ ಮಾಡಲು ಅನುಮತಿ ನೀಡುವ ಬಗ್ಗೆ. This circular issued by the Commissioner for Public Instruction, my lord. But appointment of these petition in clear vacancy and sanctioned clear vacancy port, they were appointed under Rule 48 of the 8th known. In pursuance of this annexure D, dated 13/3/2017, the directed to the first respondent institution, in pursuance of this circular, the annexure E, the publication was issued. Annexure E, my lord, page 42. T.S. Subbanna Sarvajanika Vidyasamsthe Vidyaranapur so and so. In appointment ge Nemakati Adhisuthan, they have issued an application according to their procedure as provided under recruitment rules, my lord. Then immediately there are number of branches are there, my lord.
This is for the post of
assistant teacher and assistant teacher in several subjects, my lord. Hindi, Kannada, Kala, Angla, PCM, so and so.
The petitioner is qualified. What is his
qualified, my lord? I have stated that they are graduated. First petitioner is MA B.Ed, page number 9, my lord. MA B.Ed. The second petitioner is MA B.Ed. MA B.Ed. All are qualified, having a qualification and all meritorious. They are having a meritorious for the appointment of the assistant teacher. All are BA, MA, B.Ed, MA, B.Ed.
So 12 of them.
12 of them. All are educated, my lord. That is admitted. Now, my respectful submission before your lordship is that after issuance of annexure E, that is Nemakati Adhisuchane, then the present petitioner filed an representation annexure G, my lord. Page number 45. This representation submitted by these petitioner under Rule 56 of the grant in aid rules, my lord. There is a provision, my lord. They have to submit a representation for any under Rule 56.
Grant in aid code.
I have extracted.
Under Rule
56, my lord. I have extracted page number L1 of my writ petition. Page number L1 of my writ petition. Submission of representation. All representation of whatever nature from the teacher in connection with his employment or in connection with the school to the management or to the department shall always be addressed through the head of the school. If no reply is received within the period of 2 months, he may address the management or joint director of the concerned direct. It is a Rule 56. Accordingly, as per the Rule 56, I have submitted a representation on 16/8/2018, my lord. Annexure G, page 45. Page 45. Your lordship may kindly see Vishaya. Page number 45, Vishaya. T.S. Subbanna ಸಾರ್ವಜನಿಕ ವಿದ್ಯಾಸಂಸ್ಥೆ ವಿದ್ಯಾರಣ್ಯಪುರಂ ಮೈಸೂರವರು ತಮ್ಮ ಆಧೀನದಲ್ಲಿ ನಡೆಯುತ್ತಿರುವ ಅನುದಾನಿತ ಪ್ರೌಢಿಕ ಹಲವಾರು ವರ್ಷಗಳಿಂದ ಕಾಯಂ ಶಿಕ್ಷಕರಾಗಿ ಸಲ್ಲಿಸುತ್ತಿರುವ ಶಿಕ್ಷಣದ ನಮ್ಮನ್ನು ಕಾನೂನು ಪ್ರಕಾರ ನಮಗೆ ನೀಡಬೇಕಾದ ಕ್ರಮಾಂಕ ನೀಡಿ ಮತ್ತು ನಮ್ಮಗಳ ಸೇವಾ ಹಿರಿತನವನ್ನು ನಮ್ಮಗಳ ವಿಷಯಾತ್ಮಕವಾಗಿ ನಮ್ಮಗಳ ಮೀಸಲಾತಿ ಸೌಲಭ್ಯಗಳನ್ನು ಪರಿಗಣಿಸಿ ನಮ್ಮ ಹೆಸರನ್ನು ಸೇರಿಸಿ ನೇಮಕಾತಿ ಸಂದರ್ಶನ ಮಾಡುವ ಬದಲು ದುರುದ್ದೇಶದಿಂದ ನಮ್ಮ ಹೆಸರನ್ನು ಕೈಬಿಟ್ಟು ಹಾಗೂ ಕಾನೂನು ಬಾಹಿರ ನೇಮಕಾತಿ ಮಾಡಿಕೊಟ್ಟುವುದನ್ನು ತಡೆಯಲು ಕೋರಿ ಅರ್ಜಿ. This in persons of ಉಲ್ಲೇಖದಲ್ಲಿ there are government directions. According to the directions, these representation made by these petitioner under Rule 56 of the granting rules, my lord. Now, when they are not considered with this representation, the present petitioners filed a writ petition before this honorable court, Annexure H, my lord, page number 48. Annexure H, page number 48. The writ petition sought for mandamus and direction to consider the representation dated as per annexure dated 16/8/2018. This honorable High Court issued notice to all the respondents and contacted before this honorable court. After hearing the same, this honorable High Court passed an order in the said writ petition, page number 52, my lord, ink page 52. 52. The prayer made by order question. The prayer made by the petitioner is to be considered their representation 16/8/2018 as per annexure for considering them for regularization of their service since they are working from 2007 in the respondent one institution. Page number, ink page 52, my lord. Ink page 52. Page, next page, portion of the order. Learned counsel for the respondent submitted that if the representation is in order, the same would be considered. Ink page 53, my lord. Para 2, learned counsel for the respondent to submit that if the representation is in order, the same would be considered. In the light of submission made by both the parties, the writ petition stands disposal of directing the fourth respondent to consider the representation of the petitioners and to pass an appropriate order within 3 months from the date of receipt of this copy of this order. That is annexed. Further, my respectful submission before your lordship is that in pursuance of this order passed by this honorable High Court in the said writ petition, the Parisilana Varadi, their committees formed for the appointment of these petitioner and examination, that is annexure J, my lord, page 54. Parisilana Varadi. This Parisilana Varadi in pursuance of the writ petition, that is 37-031 annexure H, ಈ ಅದರ ಆರ್ಡರ್ ಪ್ರಕಾರ ಇವರು ಪರಿಶೀಲನಾ ವರದಿ ಕೊಟ್ಟರು. In the said ಪರಿಶೀಲನಾ ವರದಿ, the authorities, the respondents given the notice and given a sufficient opportunity after considering the material evidence on record and recording the statement of the both parties, headmaster, petitioner, respondent one, passed submitted a vardi. Your lordship may kindly see all the petitioners appeared before the authority, Parisilana Vardili, page number 55, K.R. Vishwanatha and others. All the petitioners appeared, page 55, K.R. Vishwanatha and others, and all the petitioners appeared, submitted their statement, and also the opponents are respondents were also, and including the headmaster of the respondent number 1 also appeared, page number 60, my lord. Considering the all relevant statement and material evidence on record, where these petitioners were appointed by the respondent number 1, admitted. Now the respondent 1 is also filed.
You read from
ಒಟ್ಟಾರೆ ಅಭಿಪ್ರಾಯ
ಅಲ್ಲ, ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಮುಖ್ಯಾಂಶಗಳು.
Pardon?
ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ ಆಡಳಿತಾಧಿಕಾರಿಗಳ ವಿಚಾರಣೆ
ವಿಚಾರಣೆ
ಮುಖ್ಯಾಂಶಗಳು ಪೇಜ್ 61
ಒಟ್ಟಾರೆ ಅಭಿಪ್ರಾಯದಲ್ಲಿ ಬಂದಿದೆ.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ ಅಲ್ಲಿ
ಟಿ.ಎಸ್. ಸುಬ್ಬಣ್ಣ ಸಾರ್ವಜನಿಕ ಆಡಳಿತ ವಿಚಾರಣೆ ಹೇಳಿಕೆ ಮತ್ತು ದಾಖಲೆಗಳು.
ಎಸ್,
ಫಿರ್ಯಾದಿದಾರರ ಶಿಕ್ಷಕರ ನೇಮಕಾತಿಗೆ ಪರಿಗಣಿಸಿರುವುದರ ಬಗ್ಗೆ ಟಿ.ಎಸ್. ಸುಬ್ಬಣ್ಣ ಸಾರ್ವಜನಿಕ ವಿದ್ಯಾಸಂಸ್ಥೆ ವಿದ್ಯಾರಣ್ಯಪುರ ಮೈಸೂರು ಇಲ್ಲಿನ ಆಡಳಿತಗಾರರ ಬಸವೇಗೌಡರವರಿಂದ ಹೇಳಿಕೆ ಪಡೆಯಲಾಯಿತು. ಅದರಂತೆ ಆಡಳಿತದಾರರು ನೀಡಿರುವ ಹೇಳಿಕೆಗಳಿಂದ ಸ್ಪಷ್ಟಗೊಂಡ ಅಂಶಗಳು ಈ ಕೆಳಗಿನಂತಿವೆ. ಟಿ.ಎಸ್. ಸಾರ್ವಜನಿಕ ವಿದ್ಯಾಸಂಸ್ಥೆ ಆಡಳಿತ ಮಂಡಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕಳೆದ 20 ವರ್ಷಗಳಿಂದ ವ್ಯಾಜ್ಯ ಇದ್ದು, ಬಸವೇಗೌಡ, ಪ್ರೊಫೆಸರ್ ಮಲಿಯೂರು ಗುರಿಯಾಸ್ವಾಮಿ, ಅಡ್ವೊಕೇಟ್ ಶ್ರೀ ಬಿಂಬ ಎಂಬ 3 ಮಂದಿ ಆಡಳಿತ ಘನನ್ಯಾಯಾಲಯವು ನೇಮಕ ಮಾಡಿದ್ದು, ಇದರಲ್ಲಿ ಶ್ರೀ ಬಸವೇಗೌಡರವರಿಗೆ ಸಂಸ್ಥೆ ಕಾರ್ಯಚಟುವಟಿಕೆ ನಿರ್ವಹಿಸುವ ಘನನ್ಯಾಯಾಲಯವು ಸೂಚಿಸುತ್ತದೆ. ಟಿ.ಎಸ್. ಸುಬ್ಬಣ್ಣ ಸಾರ್ವಜನಿಕ ವಿದ್ಯಾಸಂಸ್ಥೆ ವಿದ್ಯಾರಣ್ಯಪುರಂ ಮೈಸೂರು ಅವರ ಸಂಸ್ಥೆಯ ವತಿಯಿಂದ ಒಟ್ಟು 11 ಅನುದಾನಿತ ಪ್ರೌಢಶಾಲೆಗಳು ಮಂಡ್ಯ, ಮೈಸೂರು ಹಾಗೂ ಚಾಮರಾಜನಗರ ಜಿಲ್ಲೆಗಳಲ್ಲಿ ನಡೆಯುತ್ತಿವೆ. ಘನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮನವಿ ಸಲ್ಲಿಸಿರುವ 14 ಜನರ ಫಿರ್ಯಾದಿದಾರ ಶಿಕ್ಷಕರು ಯಾರೂ ಈ ಸಂಸ್ಥೆಯ ಖಾಯಂ ಶಿಕ್ಷಕರಲ್ಲ. ಸಂದರ್ಭೋಚಿತವಾಗಿ ಅಗತ್ಯಕ್ಕೆ ತಕ್ಕಂತೆ ಇವರುಗಳ ಸೇವೆಗಳನ್ನು ಬಳಸಿಕೊಳ್ಳಲಾಗಿದೆ. ಇವರುಗಳಿಗೆ ಆಡಳಿತ ಮಂಡಳಿಯು ಖಾಯಂ ನೇಮಕಾತಿ ಭರವಸೆ ನೀಡಿಲ್ಲ. ಸಂಸ್ಥೆ ವಿವಿಧ ಶಾಲೆಗಳಲ್ಲಿ ಖಾಲಿ ಇರುವ ಹುದ್ದೆಗಳನ್ನು ಇಲಾಖಾ ನಿಯಮಗಳಂತೆ ಭರ್ತಿ ಮಾಡಿಕೊಳ್ಳಲಾಗಿದೆ. ನಿಗದಿತ ಶಿಕ್ಷಕರ ಹುದ್ದೆಗೆ ಇರಬೇಕಾದ ಅರ್ಹತೆಗಳನ್ನುವಾಗಿ ನಿಯಮಾನುಸಾರ ಹುದ್ದೆ ಭರ್ತಿಗಾಗಿ ಅರ್ಜಿ ಆಹ್ವಾನಿಸಲಾಗಿದೆ. ಅರ್ಜಿ ಹಾಕಲು ಮುಕ್ತ ಅವಕಾಶ ಒದಗಿಸಲಾಗಿದ್ದಂತೆ ಸದರಿ ಫಿರ್ಯಾದಿದಾರ ಶಿಕ್ಷಕರು ಹುದ್ದೆ ಆಕಾಂಕ್ಷಿಗಳ ಅರ್ಜಿ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಮೀಸಲಾತಿ, ನಿಗದಿತ ವಿದ್ಯಾರ್ಹತೆ, ಮೆರಿಟ್ ಮುಂತಾದ ನಿಯಮಗಳನ್ನು ಅರ್ಜಿದಾರ ಸಂದರ್ಶನ ಪಟ್ಟಿ ಸಿದ್ಧಪಡಿಸಲಾಗಿದೆ. ಮೀಸಲಾತಿ ಹಾಗೂ ಅರ್ಹತೆ ಆಧಾರದಲ್ಲಿ 1:10 ಅನುಪಾತದಲ್ಲಿ ಸಂದರ್ಶನ ಪಟ್ಟಿಯಲ್ಲಿ 14 ಮಂದಿ ಫಿರ್ಯಾದಿದಾರ ಶಿಕ್ಷಕರು ಸ್ಥಾನ ಪಡೆದಿಲ್ಲವಾದರೆ ಅದು ಆಡಳಿತ ಮಂಡಳಿಯ ತಪ್ಪಲ್ಲ. ಸಂದರ್ಶನಕ್ಕೆ ಇರುವ ಅರ್ಹತೆ ಪಡೆದಿಲ್ಲ ಎಂದರೆ ಇದು ಇಲಾಖೆ ನಿಯಮ. ನೇಮಕಾತಿ ಸಂದರ್ಭ ಇವರುಗಳು ಅಂದರೆ 14 ಫಿರ್ಯಾದಿದಾರ ಶಿಕ್ಷಕರನ್ನು ಪರಿಗಣಿಸುತ್ತೇವೆ ಎಂಬುದಾಗಿ ಆಡಳಿತ ಮಂಡಳಿಯು ಭರವಸೆ ನೀಡಿರುವುದಿಲ್ಲ. ಸಾರ್ವಜನಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆಯ ಮೈಸೂರು ವಿಭಾಗದ ಸಹ ನಿರ್ದೇಶಕರ ಸಮ್ಮುಖದಲ್ಲಿ ನೇಮಕಾತಿ ಪ್ರತಿ ನಡೆಸಲಾಗಿದೆ. ಅರ್ಹ ವಿದ್ಯಾರ್ಥಿಗಳು ನಿಯಮಾನುಸಾರ ಆಯ್ಕೆ ಮಾಡಲಿದೆ ವಿನಾ ನಿಯಮಗಳನ್ನು ಉಲ್ಲಂಘಿಸುವುದಿಲ್ಲ. ಒಟ್ಟು 13 ಶಿಕ್ಷಕರ ಹುದ್ದೆಗಳನ್ನು 12 ಅಭ್ಯರ್ಥಿಗಳು ಆಯ್ಕೆ ಮಾಡಲಾಗಿದೆ. ಒಂದು ಹುದ್ದೆಗೆ ಯಾವುದೇ ಅಭ್ಯರ್ಥಿಗಳು ಒಟ್ಟಾರೆ ಅಭಿಪ್ರಾಯ ದಿ ರಿಸಲ್ಟ್ ಮೆಲಾಟ್. ಫಿರ್ಯಾದಿದಾರ ಶಿಕ್ಷಕರು ಅವರ ಶಾಲೆಗಳ ಮುಖ್ಯ ಶಿಕ್ಷಕರು ಹಾಗೂ ಆಡಳಿತ ಮಂಡಳಿಯ ಆಡಳಿತಗಳ ಇವರುಗಳ ಸಂಪೂರ್ಣ ವಿಚಾರಣೆ ದಾಖಲಾತಿ ಪರಿಶೀಲನೆಯಿಂದ ತಪ್ಪತ್ತಿರುವ ಅಂಶಗಳು ಕೆಳಗಿನಂತಿವೆ. ಫಿರ್ಯಾದಿದಾರರು ಎದುರುದಾರ ಸಂಸ್ಥೆಯಲ್ಲಿ ಶಾಲೆಯ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಾರೆ. ಇವರುಗಳಿಗೆ ಯಾವುದೇ ನೇಮಕಾತಿ ಆದೇಶ ನೀಡಿಲ್ಲ. ಶಾಲೆಗಳ ಹಾಜರಾತಿ ವಹಿಗಳಲ್ಲಿ ಸಹಿ ಮಾಡಲು ಅವಕಾಶ ಕೊಡಲಿಲ್ಲ. Though they are worked in the institution, they are not permitted to sign the register in the book. ಹಲವಾರು ವರ್ಷಗಳ ಕಾಲ ವೇತನ ರಹಿತವಾಗಿ ಅತ್ಯಲ್ಪ ವೇತನಕ್ಕೆ ಇವರುಗಳು ದುಡಿದಿರುತ್ತಾರೆ. ಇವರ ಕೋರಿಕೆ ಮಾನವೀಯತೆಯ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ನ್ಯಾಯಯುತವಾಗಿದೆ. ಇಲಾಖೆ ನಿಯಮಗಳಡಿಯಲ್ಲಿ ಫಿರ್ಯಾದಿದಾರ ಶಿಕ್ಷಕರು ಮನವಿಯನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಕಂಡು ಬಂದಂತೆ ಅರ್ಹತೆ ಆಧರಿಸಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ ನಡೆಸುವ ಕಾರಣ ಅರ್ಹತೆ ಪಡೆಯದೆ ಸೇವಾಹಿರಿತನ್ನು ಪರಿಗಣಿಸಲು ಬರುವುದಿಲ್ಲ. ಕ್ರಮಾಂಕ ನೀಡಲು ಅವಕಾಶವಿಲ್ಲ. ಕರ್ನಾಟಕ ಪ್ರೈವೇಟ್ ಎಜುಕೇಶನ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಅಂಡ್ ಟರ್ಮ್ಸ್ ಅಂಡ್ ಕಂಡೀಷನ್ಸ್ ಆಫ್ ಸರ್ವಿಸ್ ಆಫ್ ಎಂಪ್ಲಾಯೀಸ್ ಇನ್ ದ ಪ್ರೈವೇಟ್ ಏಡೆಡ್ ಪ್ರೈಮರಿ ಅಂಡ್ ಸೆಕೆಂಡರಿ ಎಜುಕೇಶನ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ರೂಲ್ಸ್ 99 ರೀತಿಯ ಅನುದಾನಿತ ಶಾಲೆಗಳ ತೆರವಾದ ಖಾಲಿ ಹುದ್ದೆಗಳಿಗೆ ನೇಮಕಾತಿ ಅನುಸರಿಸಬೇಕಾದ ಕ್ರಮಗಳಂತೆ ಹುದ್ದೆ ಭರ್ತಿ ಮಾಡಬೇಕಾಗುತ್ತದೆ. ಹೀಗಾಗಿ ಸದರಿ ಆಡಳಿತ ಮಂಡಳಿಯ ಕ್ರಮ ರೀತ್ಯ ಇರುತ್ತದೆ. ಮಾನ್ಯ ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಪ್ರಕರಣ 4ನೇ ಪ್ರತಿವಾದಿ ಉಪನಿರ್ದೇಶಕರು ಮೈಸೂರು ಜಿಲ್ಲೆ ಮೈಸೂರಿಗೆ ಫಿರ್ಯಾದಿದಾರ ಶಿಕ್ಷಕರ ಮನವಿಯನ್ನು ಪರಿಗಣಿಸಿ ಸೂಕ್ತ ಆದೇಶ ಹೊರಡಿಸಬೇಕೆಂದು ಆದೇಶಿಸಿದ್ದರೂ ಇಲಾಖಾ ನಿಯಮಗಳ ಉಪನಿರ್ದೇಶಕರು ಖಾಸಗಿ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆಗೆ ನೇಮಕಾತಿ ಮಾಡುವ ಅಧಿಕಾರ ಹೊಂದಿಲ್ಲ. ಆಯಾ ಶಾಲೆಗಳ ಆಡಳಿತ ಮಂಡಳಿಯೇ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರವ ಕಾರಣ ಉಪನಿರ್ದೇಶಕ ಈ ಪ್ರಕರಣ ತಮ್ಮ ವ್ಯಾಪ್ತಿ ಮೀರಿ ತೀರ್ಮಾನ ಕೈಕೊಂಡು ಆದೇಶವನ್ನು ಹೊರಡಿಸಲು ಅವಕಾಶ ಇಲ್ಲದಿರುವ ಕಾರಣ ಹಿನ್ನೆಲೆ ಪ್ರಕರಣವನ್ನು ಮಾನ್ಯ ಆಯುಕ್ತಗಳಿಂದ ಮುಂದಿನ ನಿರ್ದೇಶ ಕೋರಬಹುದೇ. My respectful submission before the lordship is that the appointing authority is only management under the Karnataka Education Act. The appointing authority is only management, and they have to consider their appointment and to send the proposal for the approval of the candidates who are worked more than 10 months. But unfortunately, these petitioners they are not given any. They are not considered the appointment, as the management has not sent the approval, even though they are eligible, and they are worked more than 13 years for a consolidated amount of rupees 500 only. Up to 2013, they have paid the amount, but subsequently they have not paid the amount. They have not taken their work. Therefore, my respect, whenever there is a violation of the Article 14 and arbitrary in nature, their appointment, this court can interfere in the proceedings of this type of petitioner and grant a relief. My respectful submission before your lordship is that when admittedly and the entire finding in favor of the petitioner, they are eligible for the appointment of this one. My respectful submission before your lordship, kindly seize my prayer in the writ petition issue a writ, page number 24, my lord. Issue a writ in the nature of mandamus or direction, directing the respondent of 1 to 6, consider the case of the petitioner for regularization of their respective service as assistant teachers in the respective subject from the date of original appointment with monetary and service benefits. Issue a writ of nature of mandamus or direction to respondent to pay the prescribed salary to the petitioner on the basis of the principles of equal pay for equal work as provided to the similarly placed employees as assistant teacher under Article 39D of the Constitution of India. Issue a writ in the nature of mandamus or direction to the respondent to give compensation to the loss of their service and also economically suffered from the date of their appointment in the interest of justice and equity. My respectful submission before your lordship is that
Now they work from 8 to 13.
8 to 13 minutes. One more submission by respectful submission there. If there is any illegal contrary to the rules of appointment made by the management itself paid from their own pocket. There is a special 3A of the section 3A of the Karnataka Education Institution Recruitment Terms and Conditions of Service Employees Private and Aided Primary School, Milord. 2003, First Amendment. 3A add ಮಾಡಿದ್ದಾರೆ. Salary in respect of appointment made in the contravention of the rules, etc. Where the management commits any wrongful act or makes any default in appointment of any person or appoints any person contrary to these rules, salary of such person shall be paid by the management from its own fund and not from the financial assistance from the state government. This is the mandatory rules, my lord. Even assuming that they are under Rule 48 appointment for a period of 6 months only. After 6 months, they are not terminated, they are not issued any termination order. They have continued to 2013 on a consolidated amount of rupees 500 only. And these are the meritorious and master degree, having a master degree in their respective subject, my lord. Therefore, my respectful submission before you lord, there is a number of decision of this Honorable High Court. I will submit before your lordship. Court of. So lordship may kindly see. The ILR to 1995 Vajrashri versus State of Karnataka. As for the your lordship may kindly see, following the judgment of the Supreme Court and number of decisions followed by this Honorable High Court judgment. Your lordship,
Paragraph.
Para number, my lord. Para number. First of all, para number 7, my lord. My respectful submission. Para number 7. Para number 7. The petitioners learned advocate relied on 1986 SEC so and so in support of the proposition that the petitioner is entitled to salary attached to the regular port on the principles of equal pay for equal work. That is, well, Lordship may kind equal pay for equal work. Principle of equal pay for equal work. About within there can be no two options. My attention was also invited JR 1987 Supreme Court 478. The Supreme Court struck down the obstructions of the practice of the appointing teachers on an ad hoc basis at the commencement of the year and terminating their service before the summer vacation. Reliance was also placed on AIR 1990, Supreme Court 968, wherein the Supreme Court intervened even to the extent of removing the disparity in emoluments of the teachers employed in various government and private schools and teachers employed in a government school. The law in the point as well as the defined in so far as the court will not permit the deprivation of the rightful wages of the salary that is normally attached to the post of the prescribed job merely because the employer resort to some ingenious premises in order to seed the program. Now, your Lordship may kindly see page para 13, will Lord. Para number 13. Page 1851, Lord.
Yes.
These submissions can be dealt with the disposal of together. In the first instance, the petitioner is not seeking to enforce a contract simpliciter. The record of this case indicates that the respondents who were running an educational institution under the supervisory control of the state authorities were in need of teacher, and even assuming their contention is correct, they were precluded in normal course from the straightway making an appointment without sanction of the concerned department authorities. They were permitted to make a temporary appointment, which they did. The circumstances of the case are crucial insofar as the petitioner is not in any way disqualified from being normally appointed to the permanent term court, which in fact existed. If due to the combination of the factors for which the court does not have to point a finger of a blame any of the authorities, after a period of time situation emerges whereby the petitioner had been for all intents and purpose performing the job function as though she was a regular employee, and there was situation has contended for long enough, the question arises as to whether or not enforceable right have accrued to the petitioner by virtue of these subsequent development. Regularization in service by virtue of such a situation that has emerged and emanated and developed a later point of time is entirely different from the normal course of the recruitment, must also be distinguished from a situation whereby the process and procedure prescribed for recruitment are bypassed. The court is required to consider as whether the petitioner is entitled to the security of tenure which had been denied to her, as also questioned as to the whether she can be deprived of the emoluments normally attached to that court. If the answer to these two questions is in the affirmative, the court has the power to direct a regularization. Such a direction is not in conflict with the recruitment rules, nor does it constitute any infringement of those rules. And to my mind, the respondent's learned advocate was not at all justified in advancing the insolent contention that such a relief would be tantamount to a direction to the breach of the relevant provisions. The process of the regularizing an employee in an unusual situation in which the court is required to sometimes interfere and point out at the stage in which the employee is placed that the benefit of regular employment will have to be made available from that stage onwards in order to avoid miscarriage of justice. It may be in the appropriate case that regularization is directed from an earlier point of time if the circumstances justify, but this will make no difference to the legal situation at all. There can be no dispute about the fact that normal recruitment procedure cannot be and ought not to be bypassed, and that if a court finds that this has been deliberately or unjustifiably done, or that in the circumstances regularization is not in the relief, such a direction will not be issued. One needs to take cognizance of the fact of the regularization is a subsequent corrective step which purposes and admits of an irregularity at an earlier point of time, which the court neither approves nor contends. The essential difficulty arises in so far as the aggrieved employee may be at the receiving end, and the ends of justice may require that the employee should not be penalized for what has happened. In directing the regularization, the court is exercising the overriding powers whereby the process of condonation of resorted to the, because that is the only just corrective and permissible. It is now well settled law that in the appropriate cases, a court must exercise these powers in order to enforce the rights that have been accrued in favor of the employees, which are vested right and which cannot be technically relegated to the realm or of more contractual obligation, as the respondent learned advocate intended. Therefore, my respect of the next para, my lord, your lordship may kindly para number 13, 15, para number 15, my lord. And one more, my lord, para number 15. The question that emerges can be clearly summarized. My respect of submission, para number 14, my lord, there is one page number 1854, my lord. 14 dalli ಮೇಲ್ಗಡೆ on the aspect of after 1, 2, 3, 4, 5, 6
Yes.
on the aspect of regularization, petitioners learned advocate drew the attention of the court to a decision of the Supreme Court in the decision reported in AR 1990 Supreme Court 3228, wherein the paragraph 15, the court had occasion to observe that the power of regularize is the consistent with the constitutional philosophy of the social and economic justice, making a reference to Article 41 of the Constitution. The Supreme Court observed that the principles of ensuring job security is as an aspect which requires the special attention, particularly in those cases where the attempts are made to circumvent such a protection. A passing reference was also made to the apex decision of the Supreme Court in Keshwanand Bharati's case, wherein the Supreme Court had occasion to amplify the duties of the state in a situation of the type and practically. The role of the court in coming to the
Continue. We'll continue after lunch.
After lunch.
2:30, I have a list.
Much.
After that, by around 3 o'clock, you just see how the list is.
Much, yes.
End of the day, I'll take it up.
Much, I will.
Lord's permission, my lords. 34. To taken up on Monday or Tuesday, my lords. It's a connected matter.
Who appeals for the other side?
Shrikant, he's on VC, my lords.
34.1.
Huh?
34.1.
When do you want it?
Monday or Tuesday, my lords. Not
On Monday,
Srikanth,
Lords,
ಯಾವ date ఉంది, ಯಾವಾಗ?
he is appearing there on behalf of Srikanth, MD
Lords,
Srikanth.
I appear, my lords, lords may indicate a shorter date, my lords.
4th.
Obliged.
I request
Grateful.
not after sixth, my lord. Some inconvenience from the respondent. After sixth, any date.
11th.
Obliged.
Alla, Lord sir, I am the respondent here. State is 1 and 2.
ಅಲ್ಲ ಇನ್ನೊಂದು matter connected matter.
ಯಾವುದು?
First one.
34 is, that is not concerned to the management, my lords, this management.
Lord, I am in first matter, my lord, 3058 of 2022.
No, that is not 788, 7.
Let us see on that day. We'll see on that day whether it has to be bifurcated or not.
Please, 11.
11th. Arbitration short list, after which I'll resume the same. Arbitration ಚಿಕ್ಕದಿದೆ, ಅದನ್ನ ಜಾಸ್ತಿ ಮಾಡಿ. ಅದರಿಂದ
Submission, my lord, serial number 45.1, my lord. We have engaged services of senior counsel, my lord. Is not available today. Any date after 2 weeks, my lord.
You inform the other side. no?
No, I only has moved the matter. The other, all other connected matters, I only has moved the matter because the 41.1 is there only.
45.1, my lord.
45.1, that is only the matter for them, Lord. I have some extreme urgency because I have not paid almost 1 year salary, Lordship. Even though there is an order of this honorable court, it is not paid. That is the reason, Lord. They are suffering literally without a salary for 1 year, Lordship.
Let us see. When it reaches, I'll see.
Oh, much better.